Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
They got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Dati mihi Anglican Police Service Club.
Is that correct?
I didn't ask you to interrupt me.
Literally not true.
Oh, for crumb's sake.
Good morning, happy Friday. It is wonderful to be here with y'all. The weekend is nearly upon us. Just one more day to get through, and then it's all party all weekend long, right? Is that better? Good morning. There, you can hear me now. Good morning, welcome to the Court of Public Opinion. I am the Recovery Addict. Welcome, please come on in, take your seats. Fire Girl, handmade by Wendy, first in chat today. Thank you very much, Fire Girl. Wendy, I appreciate you. So don't think that I think any less of you, but I'm going to punish you. First thing, we're sentencing you to internet ownership. Congratulations. Now everything IP related or the problems connected to them are yours. Good luck. Good luck and good riddance. Keep it running for the rest of us. We have what we think will be verdict watch today. And possibly a verdict. And that's where it is. Okay, so we're going to be going to court here in just a minute. Of course, we have to celebrate all those who are celebrating their birthday today or tomorrow or the next day, and we do that right now. But you had to be on the list because why is the judge? Why is she here already? We need to sing really fast. We need to sing.
Those two are not playing.
Might have to sing later. See, Kristen PSB is on the birthday list. We could sing after she reads jury instructions. We could. We'll have plenty of time. It'll be like half an hour wait. That's all. I mean, I realize it's your birthday. You should be sung to first thing in the morning, but half an hour is not a long time to not be sung to.
Happy birthday. You look good.
You look great. Okay, let's see. Oh, we've got the list here. Just one second. I see them. Josh, thank you very much. Can we add Kristen PSB to that list?
We're on the record in the case of People versus Linda Stermer. Counselor present, Ms. Stermer is present. Jurors are all here for final instructions. Any matters to address before we bring them in?
No, Your Honor.
Yes, Your Honor.
Okay.
The elements of the charges discuss causation. Let's talk about the act. The act, it's undisputed, that caused Todd Stermer's death was the setting of a fire. Ms. Zutterbein in rebuttal yesterday said you don't have to find arson or anything with the fire, consider the totality of the evidence to find first-degree murder. Everything in every single claim and count talks about the actions of Todd Stermer. The act that caused the death is the setting of the fire. So it was just an incorrect statement by Ms. Zutterbein in her rebuttal. And I don't want the jury going back thinking we can talk about the man and the motive and everything else, but we don't have to worry about the fire in order to convict. You have to have the act to convict. So I think the jury should be instructed that there was an incorrect statement, not intentional, but an incorrect statement. The action that caused the death is the setting of the fire. That's undisputed through Dr. Markey.
Okay. Ms. Ayden?
Thank you, Your Honor. I think that's a mischaracterization of what I said. I said that I actually quoted him. I don't have my paper in front of me of what he said. And I said, you can consider all the things. I was referring to strictly, he kept saying if you don't have arson, meaning Mr. Trinkle arson, you have no case, you have no causation, you have nothing. And I kept saying you have to look at all of the evidence. So I think that's a miscategorization. I think it was very clear in my rebuttal.
Mischaracterization.
It's certainly, I was informing them that they can look at all evidence. And he said, if you don't have an arson, you don't have a crime. That's the word I heard, and that's the statement I wrote down, and that's what I was addressing. You certainly can have a crime. You can certainly have premeditated murder. You can have second-degree murder, all of her actions together. So I think that's a miscategorization of my rebuttal.
Your Honor, she said you do not have to find arson. You don't have to find the setting of the fire in order to find first-degree murder. Yes, you do. It's the action of the defendant, which is the fire, that caused the death. So it's a causation issue, and she misstated. I don't want the jury thinking they don't have to find the setting of a fire caused the death, and you can still find first-degree murder on all the other stuff she said.
Or you can still find a crime when you have creating the greater likelihood of harm and death through a second-degree murder as well, which they are being instructed on.
Every single
Counsel, I heard enough from both of you. The jury's here. I'm ready to provide them the final instructions. I'm not going to amend the final instructions. They're going to learn from me what the law is, and they're going to be instructed to follow the law as I give it to them right now. Thank you. Bring in the jury.
Judge finally puts her foot down and says, knock it off, kids. Knock it off. I'm going to give them the rules. Okay, we're going to do a little thing here. We're going to do a little thing. We're going to sing happy birthday. Ready? Because we can. See, paste right here and enter. There we go. We are going to sing happy birthday. Everyone stand up, take a deep breath, shoulders back, project your voice to the back of the room, blend your voice with your neighbors, warm up with me if you will. La 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 la. All right, we're going to sing to Kristen, PSB, Milo, Penelope, Phoebe, courtroom door, sewing your mama, and sewing mama. Happy birthday to you. Happy birthday to you. Big breath. Happy birthday, Judy, Danny, Kristen, PSB, Milo, Penelope, Phoebe, courtroom door, and sewing mama. Happy birthday to you. Judy, Danny, Kristen, PSB, Milo, Penelope, Phoebe, courtroom door, and sewing mama. Happy birthday. I realize there are a million places could be a million people can celebrate with me. You've chosen to be here with us. The privilege, the pleasure, the honor is all ours. Hopefully you can return some of that joy back to you, make your day a little more special. Begin by helping yourself to free pancakes at Denny's, IHOP, Village Inn, Waffle House, McDonald's, Andy's Grill, all the places. Tammy Dunlap's. I missed one. I missed it. IHOP? Did I put IHOP in there? Happy birthday to everyone who's celebrating. I really do hope you have a wonderful, wonderful birthday. Because it is the weekend, I'm also giving you Bob Evans. Get Bob Evans. I really think you need to celebrate all weekend long. So start today, carry through the weekend, and maybe just wrap up everything. You know, the last little toot of the party horn is going to be at Monday morning before we start live. So that whole period between now and then is just a big party. Chipotle, free pancakes at Chipotle, says Creative B. Free pancakes with salsa? What are they? Never heard of that one. Maybe it's just a free burrito. Free burrito would be good. I'm down for a free burrito. Let the dancers do their thing here for a minute. Oh yeah. Drum solo. Beautiful. And with that, the jurors are finally made their way back into the courtroom. Let's give them just a moment and let them sit down. Okay. Come on in, jurors. Come on in. It was a long walk from the jury room, so you managed to get the whole birthday song in there in that time. The results of yesterday's poll about deliberation time, most of us thought it was going to be around dinner time yesterday. So I'd say a third of us were wrong. The other third said we were going to sleep on it. which the jury has done but has not deliberated on it. So, it's we're off. Most of us we're off. A few percentage. Oh, what's that?
Welcome back, jury. Morning. Okay, do they have their final? Do they have copies?
I got a package.
Okay. I'm going to provide you the final instructions. We're going to give you copies of them now.
It's my Easter edition Courtroom Confidential shirt. It's got Courtroom Confidential in white. It's a, oh my goodness, this is a luxurious shirt. This is incredible. It is soft.
Counsel, you both have a copy as well?
Yes, Your Honor.
Okay. Sure. Members of the jury, the evidence and arguments in this case are finished, and I will now instruct you on the law. That is, I will explain the law that applies to this case. Remember that you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy, bias, or prejudice influence your decision. You must avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors who may have different backgrounds and perspectives from yours. As jurors, you must decide what the facts of this case are. This is your job and nobody else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I have already given you some instructions about the law. You must take all of my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum up, it is your job to decide what the facts of this case are, to apply the law as I give it to you, and in that way to decide the case. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that she is guilty. Every crime is made up of parts called elements. The prosecutors must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove her innocence or to do anything. If you find that the prosecutors have not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. A reasonable doubt is a fair, honest doubt growing out of the evidence or the lack of evidence. It's not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. Every defendant has the absolute right not to testify. When you decide the case, you must not consider the fact that she did not testify. It must not affect your verdict in any way. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I will now describe some of the things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. Likewise, the fact that she is charged with more than one crime is not evidence. The lawyer's statements and arguments are not evidence. They are only meant to help you understand the evidence and each side's legal theories. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyers' questions to the witnesses, your questions to the witnesses, and my questions to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers.
Thank you, Allison.
My comments, rulings, questions, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies to this case. However, when I make a comment or give an instruction, I'm not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I have excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during this trial. As I said before, it is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You're free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have and not be influenced by a witness's disability, gender, gender identity, race, religion, ethnicity, sexual orientation, age, national origin, or socioeconomic status. Again, take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see and hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth? Or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age and maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or is simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered.
Someone was lying.
It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. The prosecution has introduced evidence of statements that it claims the defendant made. Before you may consider such an out-of-court statement against the defendant, you must first find that the defendant actually made the statement as given to you. If you find that the defendant did make the statement, You must give the statements whatever weight you think they deserve. In deciding this, you should think about how and when the statements were made and about all the other evidence in the case. You may consider the statements in deciding the facts of this case. Facts can be proved by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that's direct evidence that it's raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So, for example, if you see a person come in from outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it's raining. You may consider circumstantial evidence. Circumstantial evidence by itself or a combination of circumstantial evidence and direct evidence can be used to prove the elements of a crime. In other words, you should consider all the evidence that you believe. You've heard evidence that before the trial, witnesses made statements that may be inconsistent with their testimony here in court. You may consider an inconsistent statement made before the trial to help you decide how believable the witness's testimony was when testifying here in court. If the earlier statement was made under oath, then you may also consider the earlier statement as evidence of the truth of whatever the witnesses said in the earlier statements when determining the facts of this case. When the lawyers agree on a statement of facts, these are called a stipulation or stipulated facts. You may regard stipulated facts as true, but you're not required to do so. You may consider whether the defendant had a reason to commit the alleged crime, but a reason by itself is not enough to find a person guilty of a crime. The prosecutors do not have to prove that the defendant had a reason to commit it, the alleged crime. They only have to show that the defendant actually committed the crime and that she meant to do so. The testimony of Dardita Gordon was read into this trial because she was not available. This testimony was taken under oath at an earlier hearing. You should consider this testimony in the same way you consider any other testimony you've heard in court. The defendant's intent may be proved by what she said, what she did, how she did it, or by any other facts and circumstances in evidence. You should not decide this case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. You've heard that a lawyer talked to one of the witnesses, and there's nothing wrong with this. A lawyer may talk to a witness to find out what the witness knows about the case and what the witness's testimony will be. You've heard testimony from expert witnesses. Dr. Michael Markey gave you his opinion as an expert in the field of forensic pathology. Dr. Dave Hayhurst gave you his opinion as an expert in the field of DNA analysis and forensic biology. Ann Hunt gave you her opinion as an expert in the field of serology and DNA analysis. Troy Ernst gave you his opinion as an expert in the field of fire debris analysis and trace evidence. Scott Leroy gave you his opinion as an expert in the field of fire investigation and cause and origin. Robert Trenkel gave you his opinion as an expert in the field of fire investigation, fire suppression, and fire inspection. I'm going to try my best, Zujetsky gave you his opinion as an expert in the field of injury biomechanics. Experts are allowed to give opinions in court about matters they are experts on. However, you do not have to believe an expert's opinion. Instead, you should decide whether you believe it and how important you think it is. When you decide whether you believe an expert's opinion, think carefully about the reasons and facts the expert gave for his or her opinion and whether those facts are true. You should also think about the expert's qualifications and whether his or her opinion makes sense when you think about the other evidence in the case. During the testimony of Robert Trenkel, videos were admitted as evidence to illustrate his testimony. The parties agree that the videos are not in any way a recreation of the events at issue in this trial. You may only consider the videos to help you understand and evaluate this witness's testimony as it relates to the speed at which a fire might grow and propagate in the absence of liquid accelerants under certain conditions, and how polyester clothing might burn when doused with 2 ounces of gasoline versus how it might burn in the absence of any gasoline. During the testimony of Robert Trenkle, a pair of gray polyester sweatpants were admitted as evidence. The parties agree that these sweatpants are not the same pair of sweatpants involved in this case. They are an exemplar pair of 100% polyester sweatpants. You've heard testimony from witnesses who are police officers, and that testimony is to be judged by the same standards you use to evaluate the testimony of any other witness. In count 1, defendant is charged with first-degree premeditated murder. To prove this charge, the prosecutors must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Todd Joseph Stermer. It is not enough that the defendant's act made it possible for the death to occur. In order to find that the death of Todd Joseph Stermer was caused by the defendant, you must find beyond a reasonable doubt that the death was the natural or necessary result of the defendant's act. Second, that the defendant intended to kill Todd Joseph Stermer. Third, that this intent to kill was premeditated, that is, thought out beforehand. Fourth, that the killing was deliberate, which means that the defendant considered the pros and cons of the killing and thought about and chose her actions before she did it. There must have been real and substantial reflection for long enough to give a reasonable person a chance to think twice about the intent to kill. The law does not say how much time is needed. It is for you to decide if enough time passed under the circumstances of this case. The killing cannot be the result of a sudden impulse without thought or reflection. You may also consider the lesser charge of second-degree murder. To prove this charge, the prosecutors must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Todd Stermer. It is not enough that the defendant's act made it possible for the death to occur. In order to find that the death of Todd Joseph Stermer was caused by the defendant, you must find beyond a reasonable doubt that the death was the natural or necessary result of the defendant's act. Second, that the defendant had one of these 3 states of mind: she intended to kill, or she intended to do great bodily harm to Todd Joseph Stermer, or she knowingly created a very high risk of death or great bodily harm, knowing that the death or such harm would be the likely result of her actions. In count 2, defendant is charged with first-degree felony murder. To prove this charge, the prosecutors must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Todd Joseph Stermer. It is not enough that the defendant's act made it possible for the death to occur. In order to find that the death of Todd Joseph Stermer was caused by the defendant, you must find beyond a reasonable doubt that the death was the natural or necessary result of the defendant's act. Second, that the defendant had one of these 3 states of mind: she intended to kill, or she intended to do great bodily harm to Todd Joseph Stermer, or she knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would be the likely result of her actions. Third, that when she did the act that caused the death of Todd Stermer, the defendant was committing the crime of arson. To prove the crime of arson, the prosecutors must prove each of the following elements beyond a reasonable doubt. First, that the defendant burned a building or any of its contents. The term burn in this case means setting fire to or doing anything that results in the starting of a fire, or helping or persuading someone else to set a fire. If any part of the building is burned, that is all that is necessary to count as a burning. The property does not have to be completely destroyed. Second, that at the time of the burning, the building was a dwelling house. A dwelling house is a structure that was actually being lived in, or that reasonably could have been lived in at the time of the fire. Third, that when the defendant burned the dwelling or any of its contents, she intended to burn the dwelling or contents or intentionally committed an act that created a very high risk of burning the dwelling or contents, and that while committing the act, the defendant knew of that risk and disregarded it. When there is a fire, the law assumes that it had natural or accidental causes. The prosecutors must overcome this assumption and prove beyond a reasonable doubt that the fire was intentionally set. You may also consider the lesser charge of second-degree murder on this count. To prove this charge, the prosecutors must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Todd Joseph Stermer. It's not enough that the defendant's act made it possible for this death to occur. In order to find that the death of Todd Stermer was caused by the defendant, you must find beyond a reasonable doubt that the death was the natural or necessary result of the defendant's act. Second, that the defendant had one of these three states of mind. She intended to kill, or she intended to do great bodily harm to Todd Joseph Stermer, or she knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would be the likely result of her actions. The prosecutors must also prove beyond a reasonable doubt that the crimes occurred on or about January 7, 2007 within Van Buren County. You must think about all the evidence in deciding what the defendant's state of mind was at the time of the alleged killing. The defendant's state of mind may be inferred from the kind of weapon used, the type of wounds inflicted, the acts and words of the defendant, and any other circumstances surrounding the alleged killing. Premeditation and deliberation may be inferred from any actions of the defendant which show planning, or from any other circumstances surrounding the killing. The prosecutors need not prove a motive for the killing, but you may consider evidence of motive in deciding if there was premeditation and deliberation. Motive by itself does not prove premeditation and deliberation. When you go to the jury room, you'll be provided with written copies of these final jury instructions. You should first choose a foreperson. The foreperson should see to it that your discussions are carried on in a businesslike way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communications equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on that verdict. In the jury room, you will discuss the case among yourselves, but ultimately each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. It is your duty as jurors to talk to each other and make every reasonable effort to reach agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. I've already given you instructions regarding lesser offenses. As to any count which includes a lesser offense, you must first consider the principal offense. If you all agree that the defendant is guilty of that offense, you need not consider the lesser offense. If you believe that the defendant is not guilty of the principal offense, or if you cannot agree on that offense, you may consider the lesser offense. It is up to you to decide how long to consider the principal offense before discussing the lesser offense. You may go back to consider the principal offense again after discussing the lesser offense if you want to. If you have any questions about the jury instructions before you begin your deliberations, or questions about the instructions that arise during deliberations, you may submit them in writing in a sealed envelope to the bailiff. Possible penalties should not influence your decision. If you find the defendant guilty, it's the duty of the judge to fix the penalty within the limits provided by law. If you want to communicate with me while you're in the jury room, please have your foreperson write a note and give it to the bailiff. It is not proper for you to talk directly with the judge, lawyers, court officers, or other people involved in this case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside of the jury room. When you go to the jury room to deliberate, you may take your notes and full instructions. The exhibits admitted will be available in the jury room for you to review. You've been given a written copy of the instructions you've just heard. As you discuss the case, you should think about all of my instructions together as the law you are to follow. Defendant is charged with 2 counts, first-degree premeditated murder and first-degree felony murder. These are separate crimes, and the prosecutors are charging that defendant committed both of them. You must consider each crime separately in light of all the evidence in the case. You may find the defendant guilty of both or either one of these crimes, guilty of a less serious crime, or not guilty. I've prepared a verdict form listing the possible verdicts. You will have on your verdict form as to count 1, the option of not guilty, guilty of first-degree premeditated murder, or guilty of the lesser offense of second-degree murder. And as to count 2, the option of not guilty, guilty of first-degree felony murder, guilty of the lesser offense of second-degree murder. Counsel, any objection to the fine? Yep.
Thank you.
Did I miss?
They may have made a slight mistake somewhere in the readings. We'll see what happens here. Ayden, thank you very much for the super chat. Says, I don't know if I've made a single decision that would meet the legal definition of intent. I think that's funny. Krista, OG member for 24 months. OG, welcome to the gallery. Also, Lynn in South Carolina member for 17 months. Love it hearing all you peeps. Thank you very much. Congratulations, Lynn, Krista. Allison Miles comes in also with the super sticker. Thank you very much, Allison, for that. Appreciate your support. All right, we are... dump that down to here. We'll save that part. Intent, sending the boys away. Intent, buying gas. Yeah, intent. Sedative. The other made-up word. Can somebody remember what the other made-up word was? Was it reasonably? I know we had inherent yesterday, but I don't remember what they meant to say. Was it inherent or something else? It was easily. Thank you, Katie Bug.
Couple additions. Mr. Trenko, when I talked to you about experts, he was also qualified as an expert in fire origin and cause. And this is an instruction you got at the beginning of the case, but I'll give it to you again now regarding this being a second trial. This case has been tried before, and during this trial you may hear references to the first trial. Sometimes a case must be retried before a new jury, and you should not pay any attention to the fact that this is a second trial. Your verdict must be based only on the evidence in this trial. You must decide the facts only from the evidence that you yourself hear and see in this trial. Counsel, any other objections or additions, requests?
No, Your Honor. Thank you.
Yes, Your Honor.
You're good with the instructions?
Yes. Will I get a printed copy of that?
You should have one on your...
Yeah, and they were...
No, I'm talking about the
jury already had it.
Yeah, the jury has theirs.
The added prior trial.
Oh, you're asking that does the jury, we'll give them each another copy of the second trial instruction? Okay, we'll add that. We'll just make a second trial.
Now we find out who the alternates are.
Okay, we're good on instructions then? Okay, so jury, you may recall way back in time at the beginning of this trial, I indicated that we would draw lots to excuse 3 of you. The first person we're excusing is by stipulation of the parties, and it's not random. But the other 2 names we're calling will be randomly pulled. If you're one of those persons, we're going to get you.
No. I need to know who's excused. There's a person who's excused by stipulation of both parties. That sounds like somebody who's...
Call you back in as a juror and begin the deliberations anew. We will call you when the jury has reached a verdict, and once you get that phone call from us that the verdict has been reached, then you can talk to anybody you want about the case if you wish. Okay? So we'll call the names.
No. Media cut. No audio. It verifies audio's off. And video's off. Okay. One is booted, two are random. Why would one be booted? If it's by stipulation, both sides think this is someone for one reason or another who cannot be a good juror. It may be that someone was inattentive throughout the trial. It may be that somebody had appeared to sleep or roll their eyes or just intentionally detached themselves from the case in a way that was visible to both sides. I doubt it would be number one. This is why I'm thinking number one, and we can go back and look at this, but when the prosecution began the rebuttal yesterday evening and said, Mr. Taylor, the fire investigator, didn't do anything wrong. I see your face. I know. I mean, he didn't do anything wrong by he was just doing his job. He wasn't trying to destroy a family She looked to the left of the jury box.
You do solemnly swear or affirm that you will, to the utmost of your ability, keep the persons sworn as jurors on this trial from separating from each other, that you will not suffer any communication to be made to them or any of them, orally or otherwise, that you will not communicate with them or any of them, orally or otherwise, except by the order of this court,
or that
they have agreed on their verdict until they shall be discharged. And that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they have agreed upon.
Okay, jury, you can take your notebooks with you, and I'm directing you to the jury room.
And with that, we are going to start the timer. I'm going to replace the made-up words counter with a timer here in just a minute. Stopwatch has begun. We'll get that set up. Want to jump over to Red Pen's list. I realize it's still under revisement, but let's get it as we have it right now. Press the file, download page 1, done and download. We, throughout this trial, have been tracking, as you see on the screen, the made-up word counter.
Counsel, any matters to address?
No, Your Honor.
Okay, thank you.
Thank you.
Okay, so we're now in verdict watch, and quick look here. We have the made-up word counter, which lists most of the words that were made up during this trial. We had ladies and gentlemen's, nucleus, privity, scratching, ambulance, geographics, echoline, use, guesstimation, I know some people took issue with that one, antihistamine, urine, chromatology, pacifically, impinging, not impinging, impinging, flammable, simplicit, excavate, ambulance, without the M, ambulance. We have two versions of ambulance. Portfolio, offstandish, heisted, carbureted, right? Across, especially, VCH instead of VCR, rapey, refrigerator, corroborate, centilica, perforation, hearth, easily, and incurrent. These are the words which were made up. And I appreciate you writing this on a big yellow Post-it board with a coffee stain on the bottom, which is entirely appropriate. Red Pen, thank you for assembling these. This was a fun thing to count for sure. And we'll now go back to our regular. Hey, how's it going, Miss Sorry? Hey, check out this shirt. Are you leaving? Oh. Yeah. It's from Courtroom Confidential. It's got the white logo in the corner. It's so good. It's so good.
Nice.
I might change into it. Not on camera, of course, but was there a poll on when the verdict was reached? Yes, we did it yesterday when most of us were wrong. Give me a minute to get the timer up on the screen, though, if you'll hold, please. And then we might go do a little bit of court hopping while we wait. We might also do a quick recap because it went fast, and I want to focus on something that particularly the charges. Where's my timer? There it is. Mrs. R.A. is running to the dentist with the kids. So have fun. Fun story in the castle. All right, there's a timer. I like to wait just for a minute before I put the timer on the screen because it when it's just seconds, I get a lot of complaints because it changes so fast in the milliseconds and everything else. So let me shrink this down that way and then blow it up this way. It's tricky, this one, to get the numbers the right size. Okay, I'll fix the milliseconds because that's the thousandth of a second. You don't need that. I guess it's hundredths of a second, but we'll get that up and going. What is the counter? That's the cursive counter. Which one's this? Interruption counter. That's I've got all the wrong counters. Okay. Well, we'll get that fixed here in a minute. First of all, we're going to do a quick little replay. And it will be on channel 7 because I plugged everything back in. Okay, can you hear this?
The prosecutors must prove.
Okay, here we go. Let's go to camera 7 here. We're going to review again the charges and the elements of the charge. So listen up here.
And is charged with first-degree premeditated murder. To prove this charge, the prosecutors must prove each of the following elements beyond a reasonable doubt.
So not one of them.
First, that the defendant caused the death of Todd Joseph Stermer.
Okay, to prove that the defendant caused the death, this is an act that she has to prove. This is the weakest point in the state's case because they don't have the evidence that points directly to it. Now, the judge talked about circumstantial evidence. She used the example of rain. I don't like the rain example. I think a better example would be, say, if Adam Nuske had a cat. I don't know if you do, Adam. I think you do. If you have a cat, and I know you have plants. Let's say you went to work and you came back from work and your favorite potted plant had been knocked over and dirt was strewn across the floor and you look in and you see your cat like hiding in a suspicious way, peeking around the corner at you, and you go over and you look at it and it has dirt on its paws. You did not see the cat knock over your plant and make the mess, but the circumstantial evidence can lead you to draw the conclusion that the cat did in fact knock over the plant. So we don't have video. The state did not prove to us that she lit the match, that she poured the gasoline, that she poured threw the gasoline on Todd. Or we didn't see that part, but there's circumstantial evidence that will allow us to conclude that was done. So I don't think this is a deal killer for the state in any way. Let's go on.
It is not enough the Defendant's Act made it possible for the death to occur. In order to find that the death of Todd Joseph Stermer was caused by the defendant, you must find beyond a reasonable doubt that the death was the natural or necessary result of the Defendant's Act. Second, that the defendant intended to kill Todd Joseph Stermer. Third, that this intent to kill was premeditated, that is, thought out beforehand.
Okay, let me back up a little bit because I skipped one. This one.
Second, that the defendant...
A little further. Is it clear backwards? Does it make more sense backwards for you guys?
That the death of Todd Joseph Stermer was caused by the defendant, you must find beyond a reasonable doubt that the death was the natural or necessary result of the Defendant's Act.
Okay. It's not enough to say, I left... what would be a good example of this one? It's not enough to say I made it possible. Okay, I left the back door unlocked so that the grizzly bear could come in and eat him. Okay, that it's not enough to say I made it possible for it to happen. You have to say that the act was I dragged the grizzly bear into the house and shut the door with my husband, and it ate him. That would be the act of doing it.
Second, that the defendant intended to kill Todd Joseph Stermer.
Okay, proven intent is easy if you are able to look at the circumstances. As a matter of fact, I think intent is much easier to prove with circumstantial evidence than physical evidence, because very few people in the moment of the crime document their intent. But the pouring the gas, the fight, the telling people I wish he was gone, here's how I would kill him, things like that goes to intent. And I think the state has plenty of evidence on that part.
Third, that this intent to kill was premeditated.
Premeditation, basically you thought about it beforehand, and it doesn't have to be very long. In this case, the instantaneous premeditation does not apply. There are plenty of acts and exchanges with witnesses that we have testimony from that say that this was going on for some time, that these thoughts were in her head for a while.
It is thought out beforehand. Fourth, that the killing was deliberate.
Deliberate. This means it would not be accidental. Okay, so if all that had happened was Linda accidentally ran over her husband with the van, there could be an argument made that it was accidental. If he was not burned, if he was just out working in the yard and it was, dark outside and she was decided to pull her van around the back so she could load something to the back of the house, and in negligence or just didn't see him or whatever, that could be an accident. Deliberate means that she intended for this outcome to occur, and I think there's plenty of evidence that can support that as well.
Which means that the defendant considered the pros and cons of the killing and thought about and chose her actions before she did it. There must have been real and substantial reflection for long enough to give a reasonable person a chance to think twice about the intent to kill.
Okay. The reasonable intent to think, opportunity to think twice about the what would happen. This is the moment when you're standing, like as a kid, on like the tall branch of the tree, thinking I could jump to the ground and that would be okay. And right before you jump, you're like, wait, that's enough. That's enough time to stop and think. If this was an instance where it was a split-second decision, fight or flight, there was literally no time for any other thought to enter before you made the decision that resulted in this, that would not apply. I think she had plenty of time to change. I mean, she had time to change her mind when she was filling the gas tank at the gas station. She had time to change her mind when she was telling the kids, "You guys need to go. You guys out of the house. No, you can't see your dad. Don't come back till after you've walked around at the mall, had breakfast, and then seen a movie, and then call me before you get home." There was time to reflect and change your mind.
The law does not say how much time is needed. It is for you to decide if enough time passed under the circumstances of this case. The killing cannot be the result of a sudden impulse without thought or reflection.
Okay, sudden impulse without thought or reflection. A lot of time we see that in someone that's confronted with something for the first time and like a heat of passion. You come home Valentine's Day with a dozen roses for your significant other and find them engaged with someone else, completely out of the blue, surprised. That might be a heat of passion type moment. Or let's do another one. You're out. I don't know. You're going squirrel hunting. Some people hunt squirrels. You're going squirrel hunting, you're out in the woods, and while you're getting ready to aim and you've got your guns loaded and everything, you see a little fluffy squirrel down there. Suddenly something that looks like a zombie jumps out and yells at you, and you turn and shoot, and it was your friend in a zombie mask. That's a bad example.
You may also charge.
So that's an instantaneous decision.
The killing cannot be the result of a sudden impulse without thought or reflection. You may also consider the lesser charge of second-degree murder. To prove this charge, the prosecutors must prove each of the following elements beyond a reasonable doubt.
Let's listen to the differences.
First, that the defendant caused the death of Todd Stermer.
Cause is still there.
It is not enough that the defendant's act made it possible for the death to occur. In order to find that the death of Todd Joseph Stermer was caused by the defendant, you must find beyond a reasonable doubt that the death was the natural or necessary result of the defendant's act.
Okay.
Second, that the defendant had one of these three states of mind: she intended to kill, or she intended to do great bodily harm to Todd Joseph Stermer.
Okay, so there's I intended to hurt him, but I didn't mean to kill him. Could come in on this case.
Or she knowingly created a very high risk of death or great bodily harm, knowing that the death or such harm would be the likely result of her actions.
Okay, I can see a juror member looking at this and saying, I think she poured the gasoline but didn't light it and thought, this'll teach him to get mad at me. He's going to have to run through this fire. He's going to get burned a little bit, but he'll learn his lesson. But I didn't intend to kill him. Now, you'd have to throw away some other pieces of evidence, like the van and everything else, because those are quite strong. But I can see a juror seeing that the intent wasn't there. She didn't drive fast to hit him. She didn't really use the sedative on him. I don't think she hit him with the frying pan, and I think she really did think he could get out of the fire. Now, how they come to that conclusion, I don't know how, but it's a possibility.
In count 2, is charged with first-degree felony murder. To prove this charge, the prosecutors must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Todd Joseph Stermer. It is not enough that the defendant's act made it possible for the death to occur. In order to find that the death of Todd Joseph Stermer was caused by the defendant, you must find beyond a reasonable doubt that the death was the natural or necessary result of the defendant's act. Second, that the defendant had one of these three states of mind: she intended to kill, or she intended to do great bodily harm to Todd Joseph Stermer, or she knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would be the likely result of her actions. Third, that when she did the act that caused the death of Todd Stermer, the defendant was committing the crime of arson.
So this felony murder has the crime of arson attached to it, meaning you have to find arson for this charge, that she was committing arson, burning something intentionally, home, residence, and while she was doing that, she was committing murder.
To prove the crime of arson, the prosecutors must prove each of the following elements beyond a reasonable doubt. First, that the defendant burned a building or any of its contents. The term burn in this case means setting fire to or doing anything that results in the starting of a fire or helping or persuading someone else to set a fire. If any part of the building is burned, that is all that is necessary to count as a burning. The property does not have to be completely destroyed. Second,
a fire, an arson fire could be someone lit the trash in my metal garbage can on fire and it burned a couple papers. That's enough to be an arson. It doesn't have to be it destroyed the house, the fire department was called. The fire could have gone out naturally of its own. There was just not enough fuel or oxygen for it, and it just went out and caused little to no damage. It can still be an arson.
At the time of the burning, the building was a dwelling house. A dwelling house is a structure that was actually being lived in or that reasonably could have been lived in at the time of the fire.
Okay, so the wording of that is helpful for the state because the defense tried to prove that this house did not have a final occupancy certificate because it hadn't been inspected properly. That does not get them out of this one. The way the law is written, if it was actively being lived in, it's enough. And so just the fact that they were, the boys were sleeping there that night, they had their beds and food and kitchen and a living room and TV, that was enough. And even though it wasn't officially safe from the city's standpoint.
Third, that when the defendant burned the dwelling or any of its contents, she intended to burn the dwelling or contents or intentionally committed an act.
Okay, so if we look at the pictures that were removed from the dwelling to keep them safe, I think that goes to a great deal to prove that she intended to burn it. Thus, she took the things she wanted out first.
That created a very high risk of burning the dwelling or contents, and that while committing the act, the defendant knew of that risk and disregarded it. When there is a fire, the law assumes that it had natural or accidental causes. The prosecutors must overcome this assumption and prove beyond a reasonable doubt that the fire was intentionally set.
Okay, so let me back that up just a bit.
And the dwelling.
Okay, here we go.
That while committing the act, the defendant knew of that risk and disregarded it. When there is a fire, the law assumes that it had natural or accidental causes.
We just assume that all fires just happen based on lightning or, something that was not human. Like, we assume that nobody lit the match, right?
The prosecutors must overcome this assumption and prove beyond a reasonable doubt that the fire was intentionally set.
So that is why fire investigation is so important. Because every fire under the law in Michigan is assumed that it was natural. It's like, hey, houses sometimes just spontaneously combust and there's nothing we can do about it. And unless the fire investigator can prove otherwise, it's assumed that it was natural. And now that's a big deal in this case because the fire investigator says this was inconclusive. He couldn't tell how it started.
You may also consider the lesser charge of second-degree murder on this count. To prove this charge, the prosecutors must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Todd Joseph Stermer. It's not enough that the defendant's act made it possible for this death to occur. In order to find that the death of Todd Stermer was caused by the defendant, you must find beyond a reasonable doubt that the death was the natural or necessary result of the defendant's act. Second, that the defendant had one of these three states of mind. She intended to kill, or she intended to do great bodily harm to Todd Joseph Stermer, or she knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would be the likely result of her action.
So that last second, or this lesser included, includes the option that she just created a scenario where there was a high likelihood that death or harm could happen to Todd.
The prosecutors must also prove beyond a reasonable doubt that the crimes occurred on or about January 7, 2007 within Van Buren County. You must think about all the evidence in deciding what the defendant's state of mind was at the time of the alleged killing. The defendant's state of mind may be inferred from the kind of weapon used, the type of wounds inflicted, the acts and words of the defendant, and any other circumstances surrounding the alleged killing. Premeditation and deliberation may be inferred from any actions of the defendant which show planning or from any other circumstances surrounding the killing. The prosecutors need not prove a motive for the killing, but you may consider evidence of motive in deciding if there was premeditation and deliberation. Motive by itself does not prove premeditation and deliberation. When you go to the jury room, you'll be provided with written copies of these final jury instructions. You should first choose a foreperson. The foreperson should see to it that your discussions are carried on in a businesslike way.
Okay, so we've already followed that. We're good there. Let me get rid of the replay button. Just keep one. Oh, there we go. So now we're in verdict watch. Give me a second. We're going to get the timer on the screen. If you could hold on for just 1 second. I've almost got it ready. I just need to crop it down so that the fast seconds are off. Box 1, position Y. Down there. Position X. Over there. And crop left. There we go. Okay, timer's up. 23 minutes and 30 seconds so far into deliberation. I think we are going to do one more poll because we assumed that the deliberation would start yesterday afternoon. I thought it was going to be closings at lunchtime, deliberation before dinner, but it did not happen. Try to get the gaps right here. Let's see. All right. Did I spell that right? How long will the jury deliberate? 1 to 3 hours, 3 to 6 hours, 6 to 8 hours, or more than a day are your options. I could probably eat ice cream. I love ice cream. Ice cream is delicious. She even let the dogs out knowing what was going to happen, then coaching the kids what to say is pure guilt. I'm going to guess she's guilty of lesser. I'm curious because we know that there's one juror who at least thinks, and I think we don't know if it's deliberating juror or not, but one juror that at least thinks that the state's fire investigator messed up, okay, which is a big part of the state's case. What would the conversation look like if he says, I just can't get to guilty. I just cannot get to guilty. The fire investigator didn't do his job. If he'd done his job, we would know it. But there's reasonable doubt here. Look at everything else. The testimony about her laying on a burned man, covering his mouth with her hands, hitting him with the van, buying the gasoline, telling people, the different ways that she's thought about killing him, getting the boys out of the house. That's going to be a hard position to hold, I think, because you have to discount so much other stuff. The affair, with how do you do that? Coachella starts today. Awesome. The way the jurors have been going the last couple of trials, we never know. It could happen. Lies to her friends, all the different versions of her story. And this on the defense in their closing, they actually finally addressed it. They said, "Look, we'll talk about the different versions." But the way they broke it down, they said it pretty much just means it was all just a little variation of what happened when she went upstairs from there on. Either she saw him or she didn't. Either she could see in the room or she couldn't. The fire could have been big, could have been small, could have been on Todd, could have been the whole room, could have been too smoky. Either she went out the back door or she went out the basement door. And then either she saw Todd coming out of the house or didn't see Todd coming out of the house. But at that point is where her story just goes all wrong. And for them to say it was after the fire had begun that her stories change, and you can't prove that she started the fire, thus you can't convict my client. It's not that simple. It's not that simple, and I think the jury can consider the events that happened after the fire had begun in determining guilt. It's the multiple attempts. But she's not charged with trying to suffocate your husband, and she's not charged with trying to, vehicular homicide. She's only charged with the death by arson. I'm starting to dream about Karen Reed. Not sure if that's healthy. Dog lover, I have the amazing gift or ability, I'm not sure what it is, to be able to forget what I did during the day. So I will watch court and be just completely enthralled with the proceedings of a court, with the drama in the courtroom, the arguments, the facts of the case during the day. And I'll meet up with some friends later in the night, in the evening, and they'll be like, "Hey, how's YouTube going?" I'm like, "Oh, I love it. I'm enjoying it. What case are you following?" It's like deer in the headlights. Like I don't know. It's let's see. There's a judge and there's a defendant. Let's see. Oh man, I know there's a defendant, and they have lawyers, and I don't know what it is, but I'm able to turn off my brain when it comes to some things and shut down. I think it helps a ton, because honestly, focused on murder all day, every day, if that was in my head nonstop, man, there would be some depressing times, because we have some tough cases that we deal with. Short Life Creation says, if she's convicted of a lesser charge, what is the sentence for that? And what time will time served go towards this, giving her what left? Yes, I butchered reading that, Short Life, and I apologize. Lesser charge, basically, if she's convicted of the higher charge, it's most likely going to be life without parole is the sentence. I think that's the max. Well, it's death penalty is not on the table, so yes, that's the max. The lesser charge is going to have some degree of parole after a certain amount of time. And yes, a time served will definitely count. Will 100% count. Now, we know that her lawyer, Mr. Wolf, likes to take these wrongful conviction cases, and there's probably, if she is found not guilty, that he will probably represent her in a wrongful incarceration case against the state, which is done strictly when it's a civil suit, so it's strictly over monetary damages. And I believe the state allows $50,000 per year in restitution for a wrongful conviction. So if she was in for eight years, that's $450,000 in that ballpark of 8 to 9 years of restitution that would be offered. Which, honestly, $450,000 is a lot of money, but not for 9 years of your life. For 9 years being locked up, no family, interactions, everything. I wouldn't make that trade. And Mr. Beast likes to lock people up for a while and give them money to see how long they can go without friends and family. But $450 for 9 years, no. Short-term memory issues, only about court. Like, I was worried, Marty, that I'm going a little bit insane, because that's always a possibility. But I can remember all my other appointments and dates and schedules, and it's just about this. Let's see. Virginia said, I watched some of Lori last night, and wow, I'd forgotten how really crazy she is. What about what about the crazy ones that agreed with her on weird stuff and are not in jail? How many nuts are out? There. I would say. A lot of people have very different beliefs, and I'm not going to attack those. I don't, but I'd say this: I don't think someone is crazy for falling victim to a scam. Right? People can be very charismatic. People can be very convincing. If somebody else who did not get the call on a regular basis and did not know about it beforehand got a phone call from somebody who said, "Hey, you have $1,500 in travel credits. Do you want to use them, or just should we throw them away?" Somebody might be like, "Holy cow, I had no idea. It might be a mistake, but this is going to be huge. Now I can do the trip that I wanted to do," and it's a scam. But someone else might hear that and say, "Yeah, I'm all in." Or, "Really? I missed a jury summons. There's a warrant for my arrest, and if I don't pay the fine, they're going to come arrest me, like in front of my friends and family. How do I pay?" I don't think that somebody who falls for a scam like that is crazy. And I think Lori Vallow and some of the people that she, like Chad, that she ran with, were very good at convincing people of something that to others on the outside who didn't see the step-by-step, the incremental, slowly turning up the water until the frog's boiling in the pot. They didn't see that process. Look at it and say, "Holy cow, why would you jump into a boiling pot of water, frog? That's going to kill you. They're crazy." So I don't blame them. I think they were victims. Kayla Newell, will the boys get insurance money if guilty? I don't think the insurance will pay out. No. The insurance didn't pay out because it was on the house. People are gullible. They are. And I think there are individuals out there that can sense that gullibility, that can sense a potential victim, and they'll prey on them. I think they got some insurance money from a different fire. I don't think they got anything on this one. In Sweden, they have a crazy law. If you murder someone, you get 18 to 24 years max. You're out after 75%. It's insane. But, okay, I realize that, Camilla. Tell me this. How does the murder rate in Sweden compare to other countries with different laws? Scammers leading to fears and vulnerabilities. It's very easy for someone who's in a bind or scared to fall for anything. I agree, Kimberly. Part of the reason I have a hard time getting scammers to stay on the phone with me is because I have an authoritative voice. I've got a deep, strong voice, and they're looking for someone who's weak, who can be pushed around, who may be a little timid. They're looking for someone who sounds older, who might not, who's trusting. Jimmy Jones made me do it.
AI made me do it.
AI made me do it. People want something to believe in. Yes, they do. I don't think insurance ever had a right to interrogate her. Seems like they were never, ever going to pay out no matter what. Wheeler, I don't like it, but insurance, if you look in the clause, if you look in the fine print of the insurance policy, and there is a lot of fine print in your insurance policies, this is their process. And now I've got friends that are insurance agents. I've got family members that sold insurance. I've bought insurance from family members. And I see the value of having it. At the same time, it's very much a racket. It's a bit of a scam, and it's government sanctioned because in some cases, certain types of insurance are required by law. And then when those insurance policies don't pay out, some of the refusals to pay out I think there's some companies that are worse than others. Like there's some companies that have the best rates possible, but have one of the worst payout rates. Like most of their claims are deemed to be, not covered. I'm going to close out the poll now that we've done another poll here. We've got a few votes in. Give me 1 second. Looks like we have about 700 votes in. So about 1,000 of you are missing out on deciding how long the jury will deliberate or letting us know what you think on that front. Give it just another minute. About 20 of you just voted, so might get up to about 750 or so. All right, 740, 748, 757. It's going fast. 761. I'll wait for it to slow down just for a second. Get your votes in now. Let's see. Ashlyn has an excellent question. Let me see it. Does the jury know that she's already spent time in prison for this? They almost did. They know there was another trial. But the defense said she spent like 18 years of her life under investigation. And she didn't spend 18 years of her life under investigation, but she did spend 9 years in prison. So he almost let it out. But it's anyone who understands the legal process and understands how double jeopardy works could reasonably conclude, based on circumstantial evidence and facts provided to them, that she was in fact in prison, which means she was convicted previous to this. Had a scam caller yesterday asking if I wanted to sell my house. I said, not yet. I have to bury a few more bodies in the backyard. They hung up. I love it. Courtroom ASMR. That is awesome. The call you get for vacations, if for a real guy, that is passed. So could it be a real call and not a scam? Oh, it's a real call, Donna. Here's why I say it's a scam. It is a business. It's a legitimate business that makes that call. They're lying to me, saying I have, because of some recent vacation I took, I have these credits. I did not take a vacation. I have never taken a vacation with anybody that would give me credits towards future vacations. I haven't signed up for timeshares or no. Nobody has me on that list. So when they read me that line and say, because of your preferred status, and everybody gets that pitch. And if you're lying to me to say why I'm getting this special offer, I call that a scam. So yes, it's possible that I can go through and actually buy a vacation and take the vacation using my travel credits. I would argue that I would probably get a better deal going through a legitimate travel agency, booking that travel or booking it myself than I would through this deal. When you look at availabilities, when you look at the cabins that are available and the upcharges and everything that goes with it, if you want to actually get away from a room that's right next to the engine, there's a ton to it. So I do call it a scam because it tricks people into something that's not actually true. I love Scammer Payback. Pierogi's awesome. They do some good stuff. Haven't seen Kit Boga so much, but a little bit. Okay, where was the question from Ashlyn? Does anyone know if there's a difference from this defense and her defense in trial number one? Yes, I think they're different. We know this because she got a new trial because her first counsel was ineffective. So there's no way she'd go back with the same one again. Tom Tad says, I'm not an attorney, but I have seen numerous trials. The defense team in this case was awful. You have to live in magic world to believe their exploitations regarding what happened, or explanations regarding what happened. The funny thing, Tom, is that defense actually used the term magic twice to describe events in their version of events of what happened. Todd magically made it out of the house. It takes magic to understand how that happened. Insurance is extremely litigious. Litigious. Is it litigious or litigious? Red pen, help me out. First or second? Litigious. Second, litigious. All right. Is it possible that someone accidentally becomes engulfed in flames and runs out of a house, then accidentally gets run over twice? Really bad day. Mandy, you're right. One of the judges that the one judge disagreed with this retrial being granted. Said that exact thing. She's got to have the worst luck possible. Also, my experience, I've never met a broke insurance agent. They've all done very well for themselves. They usually, I would say the agent, the one who holds the books, usually does pretty well. If you're good at selling, you do well. There are agents that work for the one who holds the books, so you could work for an agency, and generally that's good pay, but it's not necessarily fantastic. Litigious. There we go. It's the romantic scams I don't get. If you're in your later years and some hot guy starts hitting on you on Facebook, and they think you're interested in you, you need to ask yourself why. I can tell you why. People don't want to be alone. Loneliness is soul crushing. And having someone to talk to, even knowing that person may not have the best of intents, having someone to talk to is oftentimes preferable to not. Loneliness is terrible. That's why I'm here with all my friends. I couldn't do this on my own. Had someone called. If I did call back, they were shutting off my electric. Later, I called a number, and she's all of a sudden spoke Spanish. I talked back in Spanish too. She hung up fast. Approaching 45 minutes of deliberation. Loneliness is brutal. Yeah, it's good to find a friend. Pets help. Sometimes though you need a human voice to hear you and just to listen and acknowledge. My sister does a lot of Western unions at work, and they have to take training on what to look for as far as indicators for scams before processing the money. Yeah, once it's in a cashier's check type thing, it's you can't claw those back. I spend all day on my own. That's why I like to come in here, Lacey. Thank you very much. Litigious? I don't know what a short I sound is. I didn't pay attention very much in school. Law. L-A-W. I'm a Harry Potter fan, says Tanya Mackey. The magic spell used was Expecto Inflamo. Expect fire? Did we find her wand, though? Lady here in Oklahoma just scammed a bunch of women in a romance scam. Just charged by the Attorney General. It was for millions. They thought they were texting men. Yep. In the sane world, Bitcoin would have put Western Union out of business 10 years ago. It still might. Ayden. And good gains these last few hours, I think, in Bitcoin as well. Is that true? It's still on sale at 81.5, but good gains. All right. Have we heard anything about the Iowa trial? Which one, Jackie? EJF, that sounds terrible. They didn't get the money, luckily. It's horrific. Hooked on Phonics worked for me. You own a 1% piece of a Bitcoin. I have a similar chunk. A similar chunk of a Bitcoin. I don't have any updates on the rake trial. I don't know where that one's at. I have not followed that. All right. Quick question. You guys up for a little court hopping as we wait? I'd rather stare at a seal, says Greeners. Like a art seal or one of these seals. I've been watching Minecraft Court this morning. I've been saving this. Not sure if the trial's worth watching yet, but it's like this right here.
Ours and the dog.
Audio sounds terrible.
So did the dog anyway growl at you or intimidate?
I'll have to fix that. The audio is awful. Judge Simmons is live. Okay. Let's check really quickly and see who is live and who is not. I need to see here. Nope, here. Judge Chisholm. Judge Simpson is live.
Sorry about that.
My audio feed is tripping out on this. Hang on a second.
But Miss Perry needs to do that.
Sounds quite tinny. So we can't do that. I'm gonna fix that. I think I've got too many loops in here. Don't forget to close out the poll. I'll do that now. I apologize, I did forget. We've got over 1,000 votes, so here we go. We're closing it out. The results on the poll with 1,018 votes. 3 to 6 hours, half of us, 52%. Say it's going to be basically lunchtime or just before dinner. 6 to 8 hours, 19%. 1 to 3 hours, only 18%. And more than a day, just 9%. So most of us, I'd say 91% of us say that's going to happen today. Why do we call it Minecraft Court? Because the corner of the court is pixelated like Minecraft. Minecraft is a game that uses very low resolution graphics. So everything is blocky. And that's what they do to hide the identity of the jurors. I don't have any updates on the corn rake decision. Crumbly's in court. Is James Crumbly's asking for a new trial, right? Let me pull up. Do you know his reason why he's asking? We've got jury selection going on with Karen Reed. They are almost done with that one. Jose Morales going on day 5. You've got the murder trial of Tamor T.K. McIntyre. Let's see, we've got this one in verdict watch. James Crumbly's asking for a new trial. Let's take a quick peek at this one. See what's happening. We'll keep our counter going here if we can. Hang on just 1 second. We've got to get it full screen. And super source is going to be box 2 is going to be 8.
What did you do regarding, is it your Danka Labrada that makes you think that you're guilty?
We want 7, sorry.
In Mrs. Crumley's case, this is when they were together, Mr. and Mrs.
Yes, ma'am.
So she said something to the effect of, I'm going to need the shooter as a witness. And knee-jerk, I said, you can't take the fifth in front of the jury, so
of course,
you got to send up a flare if you think that's going to happen, because he can't take the fifth in front of the jury. So I pointed that out, and I encouraged a motion on that issue. And at that time, both of the defendants were together. So Ms. Smith was here and Ms. Lehman was here. So I think that's what the prosecutor is alluding to. That's back when they were together, and I was sort of surprised to hear that, because that would be a whole thing, right?
Surprised to hear what, Your Honor?
That she said that Ms. Smith said she wanted to call the shooter, and then later made it sound like I was required to compel the shooter to testify, right? So that.
Okay, so I
said, bring. This needs to be, if you think that you can bring the shooter in and I can compel the shooter to testify, and this was directed to Ms. Smith, you better file a motion, because that is not how I read the law. And so the prosecutor's point is that Ms. Lehman was there. So anything brought in this case caused a little tidal wave, and everybody to start scurrying around and researching and setting dates for pre-trials and hearings and all that. So everybody in the case knew if there's an issue, you need to tell us what it is.
So Your Honor, to respond to that, my point is that in 21 or 20, so that hearing happens, I believe it's June 27th of 22. Mr. Keese, if I'm wrong, feel free to. Okay. Is that at that point in time, there had been no invocation. No one on behalf of EC, and EC himself, had not invoked his Fifth Amendment right against self-incrimination. What had happened at those
Correct.
time periods, thank you.
At that moment.
Correct. So there was nothing ripe to bring before Your Honor in terms of filing a motion to compel testimony, because he hadn't invoked. The very first invocation happens, I think it's 1 day prior to Jennifer Crumbly's case, which is January of 2024. So
I think there was a feeling of shock when she said that, because I think everyone at that time truly believed that calling the shooter as a witness would be tantamount to dropping a bomb in the middle of the courtroom.
Well, Your Honor, and okay, I don't disagree, because Your Honor is entirely correct that you can't put a witness on the stand knowing that they're going to invoke. But no one knew whether or not he would invoke. That's number one, because he hadn't invoked. And then once he does invoke, respectfully, Your Honor, that imposes certain obligations on Your Honor. The case law is clear that when an attorney or a defendant makes a blanket invocation of the right against self-incrimination, there must be inquiry, right? The court, respectfully, is not free to simply accept that blanket assertion. So when does that assertion happen? Late January 2024, like a day before. Well, it kind of starts the day before Jennifer's trial. Then it's solidified, I believe, the first day of trial.
Well, the state court defender's office sent a letter and then sent an email.
Right, but the letter respectfully wasn't a valid invocation, because in that letter she concedes that she had not met EC yet.
But the next day she...
Correct, 100%, Your Honor. But once that happens,
EC is
right,
the shooter.
what had to happen under the case law is that EC had to be brought here for a hearing outside of the jury. 100% nothing could have happened in front of the jury. But the court is required to make a finding that the invocation is valid and that he understands it. Your Honor, given the facts in this case, I think it is, I don't want to say highly likely, but a distinct possibility that EC would have testified in his parents' trial.
The prosecution would have loved that.
I don't know that, because then all of his statements to the CFP, Your Honor, about never telling his parents that he was struggling that is the center of their case. These text messages to friend B that he is having hallucinations, which by the way, the prosecutor's own expert says he never had, okay? I mean, that goes to the inconsistent theory.
The dad, right?
She said, Your Honor, very clearly that people don't share hallucinations. And every time he talked about hallucinating with the doctor, the expert at the CFP, he talked about sharing that his friends saw the same hallucination he was seeing, which led Dr. Anaker to give the opinion that he was not experiencing hallucinations.
Okay, so
this is the dad's.
You're saying I didn't.
The dad is asking for a new trial.
Amendment issue because I didn't bring the shooter here in his bulletproof vest and put him on the stand and ask him if he was going to take the Fifth. But so you say the Fifth Amendment was not invoked, but I think it was invoked over and over again by his counsel.
No, it was invoked. I don't dispute that it was invoked. I dispute that in 21 or 22 that it was invoked, which should have led counsel to file some type of motion. It wouldn't have been ripe at that point because nothing had been invoked, and I think Your Honor agrees with that. But once he invokes, Your Honor is required under the case law to make a finding if the invocation is valid and to make sure that he understands the invocation. And that didn't happen here. And yes, I do argue that he did not have a valid assertion under the Fifth Amendment because counsel could have asked questions, Your Honor, narrowly tailored his questions, her questions, excuse me.
What question? What question would not be covered by the Miller hearing, the fact that the Miller hearing and the resulting sentence was being appealed? I think everyone in the courtroom at that time was surprised when Mrs. Smith said she was interested in calling the shooter. I can't imagine a way to call the shooter.
Because if the questions asked of EC are confined to information that is already known by the prosecution and by the sentencing judge, how can there be additional incrimination?
I don't know. I can't imagine a question he could have been asked.
Your Honor, I go through a list of 17 of them in the brief.
I know I saw them. Did you go on a camping trip? I don't think that he could have answered any of those questions. A lot of those questions are from a Miller hearing because his background...
No. That information is lifted from the CFP report. That's why I specifically tailored it to that.
That's separate, though. That's separate. Just because he answered questions in a forensic center interview doesn't mean he can be compelled to testify under oath about those questions when they would also be the subject of the Miller hearing, right?
They were already the subject of a Miller hearing. They
were
still
on appeal
already 100%. Those facts were already known to Judge Rowe. The CFP report was made an exhibit at the Miller hearing, which means the prosecution and Judge Rowe were already made aware of all those 17 facts that I list in the brief that are all helpful to James Crumbley because he is portrayed as some disinterested, negligent father, and the fact is that EC statements at the CFP do not support that. They don't support that.
I know that's your position, but try as I might, I couldn't do anything about that.
I understand that, Your Honor, but it was required that Your Honor make that inquiry. Counsel does not have to ask for it.
I didn't bring the shooter in and ask him. I didn't.
And, Your Honor, the only way to remedy that is with an evidentiary hearing.
Okay, so you want me to bring the shooter in and ask him?
Yeah.
I want the court to make sure that it was a valid invocation and that it was appropriate. That's how you correct the mistake.
I guess I would have to say then I'm satisfied that he invoked his Fifth Amendment rights.
That's
And
not
that
the
his
question.
lawyers- Okay.
The question is whether or not the blanket assertion is appropriate. Respectfully.
I'm feeling confident, respectfully.
She says, appeal me.
Your Honor, that's all I have to say on the Fifth Amendment issue. I did just have one other, and I don't know if Mr. Keese wants to respond. I did have one other sort of point that I wanted to make to the court that kind of culminates everything, but I can certainly wait, or Your Honor can just tell me to sit
I'll
down.
let him respond. And
Thank you, Judge.
One or both of you might not be happy with my ruling, but you won't say I didn't let you say everything you wanted to say.
Thank you, Judge. I'll be brief because I believe the court recalls the June 27, 22 hearing, and I do want to point out that we do assert that Ms. Lehman abandoned the issue, but that's not critique or criticism. That's just appropriate to point out for the appellate posture of the case, Judge. And she abandoned it likely for good reason, as the court has already indicated and read that friends. Now, the fact of the matter is that the shooter's own expert at the Miller hearing called him a feral child. If that information were all to come out, Judge, like you said, it'd be tantamount to dropping a bomb in the middle of the courtroom. Judge, the fact of the matter is that the information that would come from the shooter, every question would be an issue for him. There's an opinion yesterday from the Michigan Supreme Court regarding juvenile lifers, Judge. This is an ongoing issue. We're in the middle of the appeals right now. He asked for a new trial or to withdraw his plea already. That was denied. That's on the appeal currently, Judge. Anything that would have been asked by either party would be an issue for him in the Miller hearing. I think the court is understanding that. So if the court has any other questions, I'd be happy to answer. But I do just want to refer for the record back to the court's soon-to-be unsealed record regarding the forensic report and its non-exculpatory nature, and the fact that, again, we never stood up and said
soon-to-be unsealed
said,
forensic report.
As the court correctly pointed out, he does have a privilege, and all parties research that issue. Thank you.
Well, I did a lot of research about that because, obviously things that he said, the shooter said, would be of interest and relevant to both Mr. and Mrs. in their...
This is live, guys. This is live.
In their trial. But there's no support for the release of it. I looked for it because there's just no support for it. It's... The privileges belongs to the shooter and no one else. So, what else did you want to say?
I just wanted to kind of close out. I do want to address one statement made by Mr. Keese.
I'm going to let you both say whatever you want.
Thank you, Your Honor. You've been extremely patient this morning. Mr. Keese mentions that EC's own expert referred to him as a feral child. The prosecution's own expert said that EC was not mentally ill, that he was hopeful at the times preceding the shooting, that he was engaged in hobbies that he found enjoyable. So to the extent that you want to start putting out there what different experts said, it's the prosecution's expert who portrayed EC at his Miller hearing as hopeful and engaged and spending time with his parents and generally had a very good childhood without negligence and abuse. Those are, Your Honor, direct quotes. They are in the brief, and I've attached her testimony from the Miller hearing. So I am not playing fast and loose with the facts, Your Honor. Your Honor, I wanted to just sum up. Every time, Your Honor, that I've seen this topic of the prosecution's misconduct is discussed, whether it was when Jennifer Crumbley's motion for new trial was being arguing, whether it's in the press, the prosecution pivots. It pivots from the attention on its misconduct to the absolutely horrific murders that happened in this case, rather than focusing or even acknowledging their own misconduct. And Your Honor, it is, in my opinion, a very blatant attempt to distract the court and the public from how they failed to give James Crumbley a fair trial, how their misconduct robbed him of meaningful cross-examination and a chance to expose to the jury the biases of Hopkins and EJAC. This case, Your Honor, is gut-wrenching. It is heartbreaking, and it is traumatic for an entire community. But our rules and the court's obligation to ensure due process and a fair trial and full and fair cross-examination cannot bend to emotion, Your Honor. If it does, then our justice system has no integrity, and the rules mean nothing, and the Constitution means nothing. The parties must adhere to the rules, and you must enforce them equally to sympathetic defendants and to defendants who garner the most visceral of reactions, Your Honor. In this room, the law must reign supreme regardless of pain and trauma. And I can just see the headlines now, Your Honor. Callous defense counsel doesn't care about the pain of the families in Oxford. And that is not true. Your Honor, and it's funny, it's ironic because Mr. Keese just mentioned, the movement in juvenile lifer cases. When Miller was decided in 2012 and made retroactive in 2016, our courts repeatedly acknowledged how painful this change in the law was going to be for families, right? Families of victims who for decades had maybe reached a point that they could put this pain and trauma behind them, but we still changed the law. The United States Supreme Court required that mandatory life without parole be reversed, and that all these defendants come for resentencing, despite the pain that they acknowledge it would cause. In civil cases, Your Honor, sanctions are imposed to punish and deter, and all you're dealing with is money. This is a criminal case. This is a man's liberty. It is his freedom. It is his ability to live outside the prison walls. If Your Honor does not grant a new trial, you send a message to Karen McDonald and to her office that you will, and that the courts will, tolerate this type of misconduct, this type of constitutional violation. And perhaps even more troubling, you send a message to prosecutors throughout this state that failing to disclose Brady material, information that is critical to a defendant's meaningful right to cross-examination, will not be sanctioned, Your Honor. Mr. Crumbley is entitled to a discovery remedy. The only remedy that can make him whole is a new trial, Your Honor. Thank you.
Thank you. Anything, Mr. Keese?
Just briefly, Judge. Judge, throughout today's argument, I feel that my responses have been measured, and I've said over and over again that it is one thing to argue the law, it is quite another to throw around unfounded allegations. And I sincerely take issue with the fact or the allegation that we prosecute for headlines. We prosecute for victims, Judge, for victims. That's why we're here and that's why we do this job. James Crumbley was convicted because of the choices that he made, the choices that led directly to the deaths of Hannah, of Madison, of Tate, and in Justin. It was James Crumbley's gross negligence. It was James Crumbley's causation and his foreseeability that was the reason for his conviction, Judge. The evidence in this case was overwhelming. I simply ask that this court review the law, follow the law, Judge. Our brief is detailed. Our argument, I believe, is clear. Thank you.
Thank you. I don't think you can expect something from me in less than a month, probably. I'll do my best, but I've been being very careful, and sometimes I think some of my other 550 cases have taken a back seat to these two cases in the last 3.5 years. So I will do my best to get back to you as soon as possible. All right?
Thank you, Your Honor.
Thank you.
Thank you.
All right.
Interesting little hearing there. I take issue a little bit. I believe that a prosecutor should prosecute for justice. For everyone, that it should be justice across the board. Is that wrong of me? I'm not, and I've never been in the crowd that chants, say the victim's name type of thing. I want justice. It does no good punishing someone if they're not the right person, right? Yeah, we can lock somebody up, but if it's not the right person, it's not going to do any good. It's not fair. In fact, it's another wrong. But that's a tough one. This particular case is a tough issue. because it's such a terrible, terrible case involving a school shooting, and parents who, it was proven in court, according to the jury, were negligent in their parenting, and even beyond negligent, enabled their son to be able to do this through improper firearm storage and access. That's the jury's decision, and that's what's being appealed right now. But not on the jury's decision. The appeal that they're going for James Crumbly, for the dad. They're saying he needs a new trial because we called the shooter, his son, as a witness, and the day before he was supposed to testify, his lawyer said he'll just plead the fifth, and the judge said that I'm not going to allow you to call him. And what the law says, according to the defense, is that the judge in that moment should have said, okay, what we'll do is we'll excuse the jury, we'll bring the shooter in, and I will inquire of him if he understands what pleading the fifth means, if he if the blanket, I refuse to answer everything, I'll plead the fifth, you can't make me testify, if that applies, because the judge can force people to answer or hold them in contempt. And she didn't do that. And so because of that, they're asking for a new trial. So what happens here, what the strong words that the prosecutor, or not the prosecutor, but the defense used at the closing, their summation, where they're like, if you're doing this, you're sending a message that that we don't have to follow the rules. She's hinting, she's taking this to the next level. This will be appealed, probably unsuccessfully, but it will be appealed to a higher court to see if they will overrule and then order. So this is not done, even though the judge is going to make a decision in the next month, and that decision is, I would say, 99%. The decision is that a new trial is not granted. It's going to keep going after that. This battle's not over. So, all right, good stuff there. Where are we at in the timer? We're not there. Let's do 2. We're 1 hour and 14 minutes into deliberation. Man, Valo's a tough one. Oh, my goodness. The difference, it's funny. It's a stark, not funny, it's interesting. I shouldn't say funny when we're talking about any cases that involve tragedy. The interesting differences between the case we just followed in Michigan with the Linda Stermer, the law read out that for you to convict, it's not enough that she made the possibility of danger, that she created the situation where something bad could occur. She had to have a deliberate act that would make her liable. And in the parents, the Crumbly parents case, that was not the case. They were convicted because some would say they were convicted because they should have acted and didn't in their parenting. But also, as part of that, they were convicted because they enabled a situation to occur. They allowed it to happen with some knowledge, arguably, or that they should have had some knowledge that this would happen if they didn't interfere. So that's how the facts of that case went down, both of them. All right. There were good arguments on both sides. I believe it. There's a Corey Richards hearing today at 9:30. I believe, Selena, correct me if I'm wrong, is that going to be a decision on, is that an appellate? Is that the appellate decision on the change of venue? Or are they still talking other stuff? Because the scheduling's on hold. No Vallow court today. They take Fridays off. Yes, the Crumbly parents were sentenced already. They're serving life in prison. The evidence will show that Lori Vallow did do her opening statement. We are not covering Lori Vallow on Top Mark. No. Laura M., I don't have some of the big spicy moments. If somebody... Can we watch the Vallow trial of the girlfriends direct and cross? Do you have a timestamp link you can send to the burner? I can look at it. My wife's been following it, Mrs. R.A. She's enthralled with that one. Are they taking every Friday off, Jennifer? Or are they doing 4-day work weeks? Friday's off for Vallow. Okay. Let me bring in another feed really quickly. Let's go to our favorite court. I say that because they're all my favorites, but hold on just 1 second. Here we go. We're going to go to Judge. Judge. Not really Judge, but this judge right here. Give us a second to catch it. This is happening live now, but we just barely joined.
Well, it's 9:45. Do we need to wait for Vicki?
No, we'd be victim rights compliant.
We will go on the record in the matter 25 CF 32, State of Wisconsin versus Tyler Hayes. The state appears through District Attorney Kevin Schmidt in person. We have Mr. Hayes appearing in person with counsel Adam Benson. We're set today for a preliminary hearing. However, the matter is going to be a waiver, correct, Mr. Benson?
Yes, Your Honor.
Mr. Hayes, did your attorney go over with you that the burden is on the state to prove a felony was probably committed by you in Burnett County?
Yes, Your Honor.
Do you understand that by waiving your right to a preliminary hearing, you are agreeing that the state can at least meet that burden?
Yes, Your Honor.
Do you understand that at a preliminary hearing, your attorney would be able to ask questions of the state's witnesses, call witnesses to testify for you? He would also be able to produce evidence on your behalf or possibly discover things about your case. But for today's purposes, you would be giving up those rights?
Yes, Your Honor.
Do you understand that at a preliminary hearing, if the state does not meet its burden as to that felony, I could amend it to a misdemeanor or dismiss it altogether, but you're giving up those rights today?
Yes, Your Honor.
Do you understand that as a result of waiving your rights to that preliminary hearing, this matter will be bound over to a future proceeding, and that could include a trial?
Yes, Your Honor.
You understand that once you give up the right, it is forever and you cannot get it back?
Yes, Your Honor.
Has anyone made any threats or any promises to you for you to waive your right to a preliminary hearing?
No, Your Honor.
You're doing so freely and intelligently, telling the court you fully understand what you're doing?
Yes, Your Honor.
And voluntarily?
Yes, Your Honor.
I will find that you freely, intelligently, and voluntarily understand what you're doing, and I will find probable cause and bind the matter over. Information, Mr. Schmidt?
Filed the information. It mirrors the complaint.
Proceed with an arraignment or set for another date.
Let's do it now, Your Honor, please.
Understands charges and maximum penalties.
Yes.
Waive formal reading.
Yes, plead not guilty.
Not guilty pleas will be entered on your behalf. You are entitled to a jury trial. You would be entitled to a speedy trial should you request one. Mr. Benson, how far out do you think you need?
We do a status in about 45 days, Your Honor.
All right. I could do June 12th. How about 11:15?
At the moment, I have a divorce hearing in Washburn that morning.
All morning?
Probably. The afternoon's open though.
Or would you be able to do something right away at 9 and then head to Washburn?
I've got on my calendar for 8:30, so I'm assuming.
Okay, so I'm going to guess it's all day.
Not trying to be difficult.
Nope. How about June 19th?
Anytime, Your Honor, that works.
All right. How about June 19th at 10:15? June 19th at 10:15. All right, come and get your notice and you shall be free to leave. Thank you.
Thank you.
Mr. Andren, can you hear me?
Yes, Your Honor.
All right, just wait 1 second.
And then everything went away. What did I do? Did I just knock it off? Well, I pushed the wrong button is what I did. Okay, let's see. Does this work?
Of the court, we're set here today in this matter for a preliminary hearing.
Now it's working.
Mr. Benson, is this going to be a waiver?
Yes, Your Honor.
Mr. Andren, do you understand that at a preliminary hearing, the burden is on the state to prove a felony was probably committed by you in Burnett County?
Yes, Your Honor.
Do you understand that by waiving your right to a preliminary hearing, it means the state can at minimum meet that burden?
Vallow. Hang on 1 second.
Yes, Your Honor.
And do you understand that by waiving your right to a preliminary hearing, you do agree with that?
Yes.
You understand that at a preliminary hearing, your attorney would be able to call witnesses to testify for you. You'd be able to testify on your own behalf. Your attorney would be able to produce evidence on your behalf or possibly discover things about the case, which could include defenses. Do you understand that you would be giving up those rights?
We're done with that. Hang on 1 second. Let's see if we can get Lori Vallow's clip, the spicy one. We'll watch that here. Man. How did I break it? I actually made my computer be the Apple TV plugin. Now I'm confused. All right, so we're looking for... Day 3. I'm trying to find the right clip. Hang on, because I can't copy and paste. Where are you, Vallow? Day 3. Timestamp 105:02. Thank you, Amber, for these, by the way. Okay, let's go to Super Source. Box 2 is going to be 8. All right, here we go.
Can you please introduce yourself to the jury?
Hi, my name's Nancy Jo Hancock.
And do you go by Nancy Jo?
I do.
How old are you?
61.
And do you currently work?
I'm self-employed.
Do you live here in Arizona?
In Mesa, yes.
Were you born and raised here?
Born and raised here.
Do you have your own children?
5.
Do you have grandchildren?
15.
Whoa,
Busy person.
awesome.
Yes.
I'm going to direct you to a person by the name of Charles Vallow. Did you ever meet a person by that name?
I did.
How How did you meet him?
I'm divorced. I was on an LDS dating site, and when new members join, it tells you this is someone new. And he sent me a message, and we began messaging.
I've got a crackle.
Initially,
Need to get rid
did
of the
you just talk to him do you talk through the website? How does that work?
Through the website at first, and then he asked for my phone number, and then we were texting and talking on the phone as well.
Do you recall approximately when you met him?
It was early July, I believe the 3rd.
And so you said you guys would text. Was this?
A lot.
What's a lot to you?
Charles was a texter and a talker, and he was good at banter, and there were hundreds of texts by the time I had met him.
You said you talked on the phone with him as well?
For hours.
Did you have a conversation with him once that lasted almost 3 hours?
Probably more than one, yes.
When you met Charles in early July, did you know he was still married?
He told me he was in the process of a divorce.
Okay. Did you know whether or not he was living with his wife at that time?
He was in Houston. His soon-to-be ex-wife was here. When he came to Arizona, he was meeting a realtor to find a place to live when he was here as well.
So when you're first meeting him, he's out of state, but he has a connection here to Arizona, so you keep talking to him?
Correct.
As you guys are talking and texting, did you eventually have enough interest that you decided you wanted to meet him?
Yeah.
Did you know what Charles did for a living?
Life insurance is something with money. I try not to have that be the focus when I'm getting to know somebody, so that I get to know them for them and not what they do for a living.
Okay. So you didn't really care too much about what his job was?
No.
Did you know he traveled a lot for work?
Yes.
As you and Charles are talking and texting, just sort of yes or no, can you tell us, did he get very detailed about his life with you?
Yes.
Did you know if Charles had children?
Yes.
Just yes or no again, did you talk to him about his wife specifically?
A lot.
Did he mention his wife by name?
Yes.
What did you believe his wife's name was?
Lori Vallow?
Have you ever met Lori Vallow?
No.
Again, just yes or no again, did you talk to him about his wife specifically?
Okay, I got rid of the crackle.
A lot.
Did he mention his wife by name?
Yes.
What did you believe his wife's name was?
Lori Vallow?
Have you ever met Lori Vallow?
No.
Okay, now
Again,
I need to
just
show
sort of
you.
yes or no. Did Charles talk to you about
Your Honor.
why?
Objection. Leading. Objection.
I haven't heard the question yet. Go
Objection
ahead.
leading?
So just yes or no. Did Charles talk to you about why he
Leading
was
is yes or no.
No, leading is a question that suggests the answer, so she can answer yes or no.
So again, just yes or no. Did Charles talk to you about why he was separated from his wife?
Yes.
Based upon your discussions, how long did you think there had been issues going on between Charles and his wife?
For several months, but more intensely since the beginning of that year was 2019, so since the beginning of that year.
You told us that Charles talked to you in let me ask you, yes or no, did he talk to you in great detail about his relationship with Lori Vallow?
Yes.
You told us you met on an LDS dating site, right?
Correct.
So are you a member of the Church of Jesus Christ of Latter-day Saints?
I am.
Was there anything that you were hearing that you thought were outside of your beliefs?
A lot of things.
As Charles was telling you these things about his wife, can you tell us his demeanor? What his voice was like, what his attitude was like as he's talking about that?
I just remember thinking that he was strangely calm and still kind towards Lori, even through what they were going through.
You told us you were aware he had a child. Did you know where that child lived, who the child lived with?
Yes.
Who was that?
He was living with Lori at that time.
You have.
He had older children as well, but the young one was living with Lori.
You have these conversations with Charles about his wife and these things that to you seem outside the LDS religion. Why do you keep talking to him?
Well, he was very charming and kind and funny and very clever, really good banter. A lot of craziness going on around him, but he seemed pretty awesome.
Now, you guys had just known each other for a few days. Did you think you and Charles were exclusive?
Heavens, no.
So would you be surprised to learn that he was talking to other people on other websites?
Not at all.
Did he in fact share some of that with you?
He did. He shared some pictures of some woman that had sent him that were quite scanty, and then proceeded to ask him for money, and thought how funny that was, that that's what people were doing online.
Did you eventually meet Charles in person?
I did.
And how many times did you get to meet him in person?
Just once.
What day was that?
He was flying in from Houston, and we had arranged to go to dinner that night. His plane was delayed, and so I met him that night on the 10th of July.
July 10th, was that 2019?
Correct.
And was that then here in Arizona that you met?
It was.
You said that you had original plans to meet and they got pushed back?
Yeah, his plane was delayed, so we met a little later than we were supposed to.
Where did you guys meet? What did you do?
At the Keg restaurant by Santan Mall, and we ate, but we talked until the restaurant closed. We were the last people there.
So you shut the place down?
We did. I finally looked around and I realized that we were the only ones there, and told them we probably should leave, and then we went outside and talked by my truck for another 45 minutes or so.
Based upon everything you had heard, was Charles coming in to see you, or was there some other reason he was in Arizona?
Charles was ecstatic to see JJ. He was coming to see JJ. He was so excited to take him to school the next morning. He was also coming to look for a place to live. He had an appointment to meet a realtor friend after he had taken JJ to school. And then he was also supposed to meet with Lori's brother, Adam.
So you and Charles have this evening on the 10th. Were you going to meet again?
Yeah, we were supposed to meet up in the late afternoon after he got through with the things that I just said.
So did you have a set time for the next day?
Mm-mm.
Can you describe Charles? Was he a fit man? What was his size?
Very fit and into physical fitness. And while we were talking, I know that he was swimming. I got to go to the gym, and yeah, very, very fit, strong.
When you were talking with Charles on July 10th, that evening, Let me ask first, do you recall about what time you ended up meeting him?
It was around 7. I got there first, and but it was right around 7, between 7 and 7:15, I'd say.
And do you recall about how long you guys were together until you finally
Well, the
left?
restaurant closed at 10, and they were closed, and no one else was there. So it was after that we left, and then
They're like, you
I
guys
said, we
have to go
stood by my
home now.
truck and talked for another half hour, 45 minutes after
That you have
that.
to stay the whole night. We're locking the doors.
So a later evening.
Yes.
Can you tell us, you said that you understood he was going to go see his son. What was his demeanor
Let me work on the
about
audio
with
here.
regards to JJ and seeing his son?
Like a kid on Christmas morning. He was very excited to see JJ.
You had talked about his demeanor when he would talk about his wife. On that evening or ever, did you ever hear him swear or use derogatory names or anything like that towards Lori Vallow?
I was surprised with the details that he was describing to me, how kindly he still spoke about Lori, and his hope was that she would be a great mom for JJ.
Did that stand out to you?
A lot.
Why?
Most men that you date are not nearly so kind about their ex and describe them in more derogatory ways and don't speak so kindly. And I remember just thinking how odd, in a good way, it was that he was not speaking in a derogatory way about Lori.
So that made an impression on you.
It did.
During any of your conversations with Charles, did you ever learn that he had a life insurance policy?
I did.
As you are talking, did Charles really just tell you a lot about his life?
A lot about his life, yes.
Were you almost surprised at the amount of detail of his life that you learned?
Yeah.
Did you understand whether or not any changes had been made by Charles to the life insurance policy?
He told me that he had changed his beneficiary to his sister, Kay, and as he was proceeding to tell me some of the things that were going on, I suggested to him that maybe he should let Lori know that he had changed the beneficiary on his life insurance to Kay.
Why would you tell him that?
Because of the things that he was describing to me and his concerns for his safety and the thought that money would come into play.
Do you recall where you were when you made that suggestion to Charles?
We were sitting at dinner at the Keg.
So this is on July 10th.
Correct.
What was his demeanor like when you told him that?
He kind of chuckled and said that he probably should.
The media room is
Said that was a good idea.
Is separated and has a glass one-way window.
You told us that you don't know Lori Vallow, correct?
I do not.
Would it be fair to say that you sort of have no beef in this case?
I have no beef in this case.
Do you know
Ain't got no beef.
Charles's family back then?
No.
Any of Lori Vallow's family back then?
No.
Where's the beef?
When you,
no, that's the pickle.
I guess, left Charles after talking in the parking lot that evening, you told us that you had sort of unformalized plans to see Charles the next day.
Correct.
Was there like someone would call someone, or how was that supposed to go?
He just said that he needed to do the things that I said, have a morning with JJ, find a place to live, meet up with Lori's brother Adam, and then we would meet up somewhere for a late lunch or something.
Did you ever try to reach him on July 11th of 2019?
I did.
Did you try texting him ever?
Around 11-ish in the morning, I texted him and asked how his morning with JJ had been.
Did you get a response back?
I did not.
Did you try calling him?
A couple hours later, I called once, yes.
Did you get a call back?
I did not.
What were you thinking when you didn't hear from Charles after you spent this night?
I was puzzled how I had misread what I had thought been a good date so wrong that he would not even take the courtesy to reply. Wondered why, but just figured that was what his decision was.
So on July 11th, when you're not hearing back from Charles, did you know that he had been shot and killed?
No.
Oops, that was bad. Sorry.
Did you later learn that Charles had been killed from seeing something on TV?
I was watching TV in December, I believe, and his picture came on the screen, and it said that he was dead.
How long later was that?
When you learned that in December, that he had been killed, did you learn when that had happened? Did you try to investigate?
I did. They said the date, and I thought, oh my gosh, that's right about when I went out with him. And so I went to my phone and thought I probably had deleted our text conversations. If I'm not dating someone and I text, I usually delete the thread, but I had not. And I had the conversations, and then I realized that I was with him until 10:45 that night and that he died at 7:30-ish the next morning.
And did you later then talk with the police in April of 2020 to tell them what you knew about this case?
I did.
Thank you. The state has no other questions.
Cross.
Nancy Jo, right?
Correct.
And we have not met before, correct?
We have not.
Okay. And you stated that your husband, or my husband, told you that he was going through a divorce. Is that correct?
This is Lori Vallow talking now.
And did you have any way to verify that?
No, I didn't try to verify that.
Okay. So did it surprise you later to find out that we were not in the process of a divorce?
Charles was in the process of a divorce.
He was not in the process of a divorce. Did it surprise you to find that out? You've seen it all on TV where we're not getting divorced.
Okay.
Okay.
So on the website that you met him, did he say he was divorced?
I'm not certain.
Would you have gone on a date with him if he would have said he was married?
If I would have realized how married he still was, maybe not.
How married?
But I just met for dinner. I wasn't sleeping with him or anything.
Do you go on dates with married men?
I'm going to
Not
object
naturally?
Argumentative. I'm going to also object under 611 for harassment.
All right. I'll sustain the objection.
Your Honor, do I not have a right to cross-examine this witness for what she has already testified to?
You can cross-examine her about what she's testified to.
Allie B.
So you did go on a date with a married man,
I went on a date with Charles.
Allie, that's
but you did not know he was married.
I knew his divorce was not final.
For Allie B.
His divorce was not started.
Okay.
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 Okay. Allie
So
doesn't
in your
accept
text
his
messages, you asked Charles if he was a good kisser. Is that correct?
Maybe, sure.
Did he answer that text message?
I'm
gonna
sure.
object to
I'm sure he did.
relevance. Again, 611 harassment.
I'll sustain the objection for relevance and hearsay.
Relevance and hearsay.
So are you trying to tell me and this jury that you went on one date with my husband and he told you all the details of our lives?
I'm telling you the truth, and that's what I know.
So you spent your whole date getting to know each other, talking about me.
This is personal.
Don't flatter yourself. No, we did not spend the whole time talking about you.
You knew a lot about me, right?
I knew what I've testified to.
What else did you talk about on your date?
Lots of things.
Like what, for instance?
Life, kids, the church, lots of things.
Okay. Did he tell you about anything about our other 4 children?
Yes,
So you knew that we did have 5 children as well?
I did.
Okay. Did he talk to you about my daughter Tylee?
He did.
Did he talk about his relationship with her?
I don't recall that.
Did he talk about the contention in his relationship with my daughter Tylee?
I don't recall that.
I'm sure you don't.
And I'm going to object to comments
Commentary.
by the defendant made after
Sustained.
questions testifying.
Let's sustain the objection.
On your date, you talked about my husband was a life insurance salesman. Is that correct?
I knew he did something with money and insurance, but I really didn't know the details of what he did for work. Like I said, I don't ask the details about what someone does for work when I'm trying to get to know someone.
But you knew that he sold life insurance. You stated that.
I believe that I had a vague understanding that he did something with insurance.
And then he brought that up again at dinner.
No, we didn't talk about his work at dinner.
I thought you said you did talk about, and correct me if I'm wrong, you said you did talk about that he changed the life insurance policy at dinner.
Well, you were asking me if we talked about that he sold insurance, which that didn't happen. But yes, he did tell me that he changed the beneficiary of his life insurance policy at dinner.
Did he tell you how much his life insurance policy was for?
Yes, he did.
What did he say?
$1 million.
Did he tell you how much my life insurance policy was for?
I do not recall.
You don't recall?
We didn't talk about you very much in that vein.
When did you talk to him about me very much then? If it wasn't at dinner, was it in your text messages?
We were talking about what he was going through in the process of separating from you, not about what your life insurance policy was worth. And we talked about you on the phone, and when I say you, meaning what he was doing as he was going through this separation.
So let me understand. You were dating some different men on this website, right? From the websites?
Sure.
Would you say it was common for men to be talking so much about their supposed ex-wives during their conversations with a potential?
It's actually very common.
Really?
Really.
Interesting.
And again, Your Honor, I'm
right.
going to object to the defendant making comments after her questions. and
I'm
move
sorry,
to
Your
strike.
Honor. I won't do that again.
All right, please stop.
I'll just ask the question.
I bet you will. I mean, I'm just dollars to donuts. I bet you will.
So there were some text messages between you and my husband after the dinner on July 10th. Is that correct?
Correct.
What time would those text messages have occurred?
After dinner,
What time?
10:45-ish.
10:45 to what?
I'm not certain, ma'am. After dinner.
10:45 to midnight? Maybe?
I just told you I don't know. Maybe.
What did you discuss in those text messages?
And I'm going to object to relevance again. If there's a specific area.
Sustain.
You testified a minute ago that Charles told you a lot of things about his wife. You didn't say ex-wife, but you said wife. Is that correct?
Okay, sure.
What were a lot of things?
The things that I've testified to.
Can you be more specific?
Am I allowed to do a narrative then?
Let's go on sidebar.
Oh my goodness. Okay. Let me just say this really quickly. this is a terrible, terrible case with a fact pattern that is extremely confusing. This witness is doing an amazing job with the pro se defendant who does not know a thing about the law, but is going through the motions as if she does. You don't generally want a witness on the stand who is against you testifying in the narrative, because they can say all that they want to say. And stuff might come in that you don't want. You generally don't want a witness testifying in the narrative, period. It's used when, say, like a lawyer, their client wants to testify. They say, we don't recommend you don't. And we know you're going to get up there and say something that's not true. And say, Your Honor, I just want to testify in the narrative. Let them tell their story, their version. Lori doesn't care. I would say this. My impression of this is Lori does not care about the outcome of this trial. To her, this is getting back at. This is revenge. This is making other people in her life that she thinks has wronged her pay through the questioning at trial. It's almost like she's collecting information for her little black book. I don't know, voodoo dolls back in the cell.
This witness shouldn't take too much longer. I'll have the jury wait for a few minutes. We'll see if we can finish this witness as we go into the lunch hour. But I'll excuse the jury for just a few minutes because we're having technical difficulty with the court reporter being able to hear.
Should listen to our feed. We've got the audio. Great. We're going to skip forward just a wee bit because we can. Give me just 1 second. Looks like we are back right here.
If you want her to answer the question, I'll have her answer the question.
How am I supposed to know what a lot of things are?
All right. If you want her to answer the question and there's no objection from the state, we'll
No
bring
objection.
the jury back in and have her answer the question. All right.
In the narrative. Here we go. It is a vendetta. It's extremely personal. It's more than that. Lori is going on. It's like she's collecting a list of people to understand the true scope of how she got caught and how she got in trouble. She's finding a list of bad people. If she's doing this, and I think she is. I think if you went back to her jail cell, she's going to have like her court notes and then her personal black book notes of people she hates. And clearly this witness is near the top of the list. And she must think that at some point, either she or God, because she's very tied up, her beliefs in that she was doing what was right is tied up in this. It's going to make this all right. Either she will make it all right, like she did with Charles because Ned had taken over, or God will. One of these two things are going to happen, and it's her job to document this and to expose it all to the world. They go to lunch now. They carry on after lunch. Okay. So let me jump to 3:20 then. Is that when the... Let's see. Looking for Amber's message with the timestamp. 3:02. Okay. So we're not going to miss anything. Hold tight. We're just going to jump straight to after lunch, which was 3:02:06. Man, they got a long lunch. I need to move to Arizona if you get lunches that long. I get like 15 minutes on a good day. Okay. We're back. We're back.
Miss Hancock, you said that you had seen on TV that my husband had passed away. Is that correct?
That's correct.
And you indicated after that you saw my sister-in-law, Kay Woodcock, on that show, and you reached out to her. Is that correct?
I didn't indicate that, but that is correct. I reached out to Kay after I saw that Charles had died.
Okay. And did you do that through Facebook or?
I did.
Social media? Okay. How many times between that first contact and now have you and Kay Woodcock communicated?
I've spoken to her just once. I've texted her here and there regarding. I've texted her here and there about other things. I don't know what I can say.
Okay. How many times have you texted her?
I have no idea.
Like more than 10?
Maybe.
Okay.
Okay.
Have you ever turned over those communications to the state?
No.
Did they ask you for them?
No.
Okay.
You've got mail.
Did you ever turn over the text conversations you had with my husband to the state?
I was never asked, but I understand that they retrieved them via having them through Charles' phone.
Okay.
I would have had I been asked.
Okay. Did you turn over any other communications that you had with anyone else regarding this case to the state?
I don't believe I've had any other regarding this case to turn over to anybody, so no.
Okay. How many times have you spoken to this prosecutor?
To Ms. Kay?
Yes, to Ms. Kay.
I met with her once in person and one other phone call, and then just text messages about the logistics of being here today.
Okay. How many text messages would you say?
I have no idea.
More than 10?
I know court was running behind, so she had to text me to come at a different time. Probably counting yesterday and today to redo the time, more than 10, yes. Prior than that, probably no.
Okay. Did you have a meeting with her to prepare for this testimony?
I met with her once.
How long was that meeting?
An hour, maybe an hour and a half.
Okay. Was anyone else there?
No.
Have you ever spoken to my brother, Adam?
Yes, but only because I ran into him at my grandson's pickleball tournament the other day.
Pickleball. You'd tell Weather Watch. You'd be proud.
How did you know that was him?
Because you said hi.
Because
I'm Lori
I've seen
Vallows.
him on media via the situation surrounding you.
So you initiated a conversation with him?
I just said hi, and he asked me who my grandson was, and I pointed it out, and that was the end of it.
So you introduced yourself to him? To my brother?
I don't know that I introduced myself, but maybe.
How would he know who you were?
I don't know that he knew who I was. I knew who he was.
So you went up and talked to him?
I did talk with him, yes.
He didn't call you over, so you went up and talked to him?
Yes, ma'am.
Okay. And when you were talking to him, you told him you were who?
I told him that my name was Nancy Jo Hancock.
And did he recognize that name from something?
Can I go back and change how I met your brother? I forgot this until right now. So on a dating app, your brother's picture came up on my dating app. And I sent him a message and said, but he had a different name that he used, not Adam. And so I just sent him a message and said if he was going to use someone else's pictures, he should probably pick someone different than Adam Cox.
Oh.
That's how I met him.
That's how you met my brother, Adam?
Correct.
Do you know what perjury is?
Absolutely.
Can I object, Your Honor, to
question.
Argumentative harassment?
Argumentative.
How long was this conversation that you had with my brother at the pickleball tournament?
A couple of minutes, maybe less.
And how many times had you communicated with him before that?
Only that message on that dating app. Besides that,
one message, one time?
I don't remember. I think he messaged me back, and it didn't continue.
So just the one day then? Maybe several messages in one day?
I might have sent him one other message, but it was just one interaction, and there was nothing further.
And you did not schedule a date with him?
I did not.
Okay. Have you ever spoken to Brandon Boudreau?
Yes.
Okay, when?
He attends the same church that my daughter does, and he happened to be at their house briefly, and I didn't really speak to him. I just knew that that's who he was.
And how did you know who he was?
Because my daughter told me.
And who did she say he was?
Brandon Boudreau.
In relation to me?
She knows the story, and I know the story, so she just had to tell me that his name was Brandon Boudreau.
That he was married to my niece? Is that the information that you had?
I know that he was married to your niece, yes.
Okay. Just the association is all I was asking. And you did speak to him that time?
Well, I don't believe I spoke with him.
Okay. Yeah, but you met him? Or
I don't know that I even met him. I was there. He was there with some other people, and I knew that that's who that was.
So you didn't introduce yourself to him?
I did not.
Okay. Did you speak to any other law enforcement besides Miss K? Not that she's law enforcement, but did you speak to any other law enforcement about this case or be interviewed?
Yes.
Who? Who did you speak with?
Lori doesn't know these answers. It's crazy.
Detective Moffat is who interviewed me. I believe that's... I might have left a message for him. I couldn't tell you who with, but the only one that I spoke to was Detective Moffat, Nathan Moffat.
And when was that interview?
It's like she's doing discovery work right now.
In 2020, I believe in April. A long time ago.
Okay. How long was that interview about?
It was a telephone interview, and it lasted 45 minutes, I'd say.
Is that the only law enforcement that you spoke to besides the prosecutor?
Yes.
And how long between that interview with Detective Moffat and your first communications with Ms. K, how much time passed in between there?
Still watching
With
Michigan
Trina K?
Court. It's up in the top
Correct.
corner.
I met with her just a month ago, 5 weeks ago, and I gave an interview in 2020, so.
Is that the first communication you had with Ms. K was 5 weeks ago?
Yes.
Okay. Ms. Hancock, were you aware at the time of your date that I did not know that my husband was on dating websites and dating women?
Objection, speculation.
Sustained.
I don't know. I don't think
Were you
that was
informed by him
I
that
think she should have answered that one.
that I knew of the situation of us being separated?
He was under the impression you were having an affair, so him moving on was a natural effect from that.
He told you that?
Yes, he did.
Okay.
He told you I was having an affair?
Just to recap, you said that you met my husband Charles, on July 3rd. Is that correct?
Approximately.
Day before he was murdered.
Give or take a day.
A week or so before he was murdered.
And you went on a date with him on July 10th?
Correct.
So that was what, 7 days later?
Approximately.
So would it be fair to say that you knew my husband for a week?
Approximately.
Okay. And then you had no contact with Charles after that, correct?
Well, he was dead, so clearly I didn't have contact with him.
Okay.
She's always like, that doesn't stop me.
And it wasn't until you saw that he had passed away on the news that you reached out to anyone, is that correct?
Correct. I didn't know he was dead.
And that was about 6 months later? Is that correct?
I believe it was December, so July to December is 5 months, I believe.
Okay. And then you found Charles' sister, Kay Woodcock, my sister-in-law, yes?
Objection asked and answered.
I'm just going over the timeline, Your Honor.
I'll allow it. Go ahead.
So when is the then you're referring to?
So at the 5 months later that you said in December, after that is when you contacted Kay Woodcock?
To express my condolences for her brother passing away and wanted to let her know that I had had dinner with him that last night and how much he loved JJ and how excited he was to see him the next morning. And just...
Thank you. That's enough.
Thank you. That's enough.
I'm just recapping here. And you contacted her through Facebook, is that correct?
And again, asked and answered.
I don't think that was actually asked yet. I'll overruled. Go ahead.
Yes, as I said before, I contacted her through Facebook.
Okay. And then sent a few text messages, is that correct?
That is
Yeah.
correct.
This is recap of everything we've already gone through.
Gonna sustain that one.
And then you said you met with police on April 22nd, 2020, is that correct?
I didn't say April 22nd. I said I believed it was sometime in April.
Okay.
And I didn't meet with them. It was a telephone interview.
Okay. And that was around 1 year after my husband passed away, is that correct?
Well, July to April would be 10 months, so.
No more questions, Your Honor?
All right, redirect.
Thank you.
Wow.
You, did you reach out to the police or did the police reach out to you after you learned Charles was?
I reached out to the police. I was surprised given that if they had seen his phone, they would see the text communication that we had had and that we had been at dinner that night before he died.
In terms of speaking with Charles's family, Kay Woodcock, did you know her before this?
No.
Had you heard her name through speaking with Charles?
Yes, from Charles. I knew that he had changed his life insurance to his sister Kay, and he talked quite a bit about Kay and his love for her and the relationship with JJ and how that they had adopted JJ.
So you understood the closeness he had with his sister?
Absolutely.
And you said you reached out to pay your condolences?
I did.
When you learned that Charles was dead, were you shocked?
I was watching the TV and it was talking about a case and his picture came on the screen and shocked is an understatement, yes.
In terms of talking with Kay, have you ever tried to talk to other people to learn about or verify if the stuff that Charles told you is accurate?
No.
Is what you are telling us just what he told you?
What I'm telling you is part of what he told me. There's a lot more.
And did you tell the police all of what he told you? That you could remember at that time, I should say.
I believe, no, I thought I would probably be interviewed again, and it was more an ask-answer format. There was, I believe, I remember being surprised that I wasn't interviewed again.
Okay. Because Charles had shared so much with you.
Correct.
In terms of
I see a graphic
the
equalizer
defendant's
in the
brother,
background.
Adam,
The little lights
did you
to the
ever
right
talk
of the
with him
witness.
about the case?
No.
Through media, did you recognize him?
I
as-
recognized him because I'd seen him on reports. And I knew that he was going to be testifying in this hearing.
When did you see him? When was this interaction
Like
at this pickleball?
a week and a half ago.
So a week and a half ago, when you see him at a pickleball tournament with
Mhm.
your grandkid, you say hi to him?
Basically.
You don't talk at all about the case?
We might have talked about that we were testifying. I don't know. No details for sure.
Okay.
Just a general, and then he saw who my grandson was, and the end.
So nothing about, hey, I'm going to say this, or Charles told me this?
Absolutely not.
When you and I met, did we go through your testimony? Or let me get this right. Did we go through what you told the police?
Yeah.
Did I indicate to you to just tell the truth?
You told me to tell the truth.
Whatever that was.
Whatever that was.
You were asked about the fact that you knew Charles for basically a week, right?
Correct.
Did he make an impression on you?
Charles was a large personality. It would be hard not to be impressed by his wit and
charm.
Just gregarious, big personality.
Gregarious. Great.
With his southern accent.
You were asked a lot on cross about you dating a married man.
Correct.
What was your impression of where this relationship was between Charles and Lori Vallow when you and Charles started talking?
Well, I knew that they had separated and that they had reconciled, and I knew he had filed, and then he had recanted that. But he also had met with an attorney to begin the process again, and was very emphatic that he was done with all the craziness.
And was that last time something that you understood to be very recent?
Prior to us meeting?
Yeah.
Yes.
When he's talking to you, he's telling you about, you said, sort of the whole year of 2019, correct? But this last understanding that you had of him now going back to a divorce lawyer, was that something you understood to be very recent in time to that July 10th when you're meeting?
Correct.
Okay. And did you understand him to have even met with an attorney?
I believe he told me that, yes.
So that was where you were at?
Yes.
And that's what you understood Charles to be at?
Yes, and I will say, after having dinner with him, I did tell him that no one would want to be serious with him until he was further along in accomplishing that divorce that he was in the process of, including myself.
So even though you knew he was just barely starting now, did you still want to meet with him again?
Yeah, I wouldn't have entertained a serious relationship, but he was fun, and yeah, I would have met with him again.
All right. I have no other questions, Your Honor.
Are there any questions for this witness from the jury? I see at least one question coming down. I think we have our white noise, our
Jury ask questions?
Yep.
Need to watch more true crime. This is interesting. To understand some of the intricacies of this case and why certain things are an issue. In the Church of Jesus Christ of Latter-day Saints, there is a strong moral code, I guess you could say, where it would be frowned upon in a big way to date a married man. That would be no-go zone, right? More so outside of the church, relationships can be defined by the individuals who say, we have this type of relationship. It's open. They knew they were dating other people. It's fine, and that's how they define it. Within the church, a marriage has very clear boundaries, and even the just going out on a date with someone who is married would be you did what? Type thing. So let's see. So that's why Lori was doing the questioning, saying, is it your habit to date married men? That's the jab she was getting at. That was a jab through the religion at the witness, not like personally. Is that just what you like doing? So, all right, we can fast forward. If your comments are not showing up on screen, it might be using a word that we've banned on the channel. Just so you know, I've seen several of them that I show up on my screen but never show up in chat. So try to find other words for it. It's Kathy. It's not. It would be marriage. It would be a civil marriage. Anything. The sanctity of marriage is what defines it. So, if two people, members of the church went down to the courthouse and got married by the judge, it would be the same. Crossing that boundary of then one of them dating someone else or someone dating one of them would be the same. All right. The comment was the pot being introduced to the kettle. Yes. And she brought back, she snapped back. She's like, well, he told me that you were having an affair. And so he felt justified in doing this because he knew the relationship was over. Could have asked you the same thing. Yeah. We can fast forward. We're going to try to get some of these spicy bits. We've got 2 hours and 20 minutes of deliberation in the state of Michigan right now. So about 40 minutes to come in if you were of the up to 3 hour deliberation time. If you were of that group, only 40 minutes left to come back with that. No questions yet asked from the jury in Michigan. So we're waiting for the question from the jury real quick. I want to see the end of this testimony. Don't want to fast forward too much. But let me fast forward just a teensy bit so they can see. I don't want to. If it's going to take 10 minutes to ask the questions. Okay, here we go. Looks like they're done with the jury question discussion. Let's see what they asked. And the interlacing on this is driving me nuts. To the edge of the water bottles when we pan back and forth.
Does the defendant have follow-up based on that juror question?
Oh, no, Your Honor.
Where's the juror question?
No.
All right, you can step down.
Stop. How did I miss the juror question? I'm trying to find where the juror question is.
actually asked yet. I'll overrule. Go ahead.
Yes, as I said before, I contacted her through Facebook.
Okay.
Did they not play
And
the
then
jury
sent
question?
a few text messages, is that correct?
That is
Yeah.
correct.
This is recap of everything we've already gone through.
Let me see if I can find. She turns to the judge and says, "So jurors ask questions." We sit here, we wait for a little while. I don't get the question. Did they ask it? I didn't hear this, so. There's only one question. The question was Charles stressed? The answer was very. Kathy, thank you for that. In that case, we're going to skip ahead. If there's another segment of the trial you guys would like to see. Go back here. There we go. Let's see, Amber, is there another point? You said K. Was K from yesterday or from 2 days ago? They don't publish jury questions? Tracy, that's terrible. Is it because the juror asked them out loud? Adam or Kay are very spicy. Just play all our cross exams. So let me jump to yesterday because yesterday was day 4. This is from day 3. So give me just a second. We're going to pull up the latest and greatest. What happened yesterday? Day 4. Does anybody have a timestamp of day 4 when that happened?
Not anymore?
No.
So we just ignored you.
Yes.
Where'd you end up staying?
My mom and dad's house.
Okay.
I just started it.
On July 10th, did you understand Charles was also flying into Phoenix?
Yes.
Did you see Charles on the 10th?
No, I did not.
Did you see your sister Lori on the 10th?
No, I did not.
So
this is Adam.
You told us you stayed with your parents. What did you do on the 10th?
They picked me up and we went to lunch. And then we just, I think, hung out at the house.
You said your son Zach lived here at the time?
Yes.
Who was he living with at that time?
I think he was living with my mom and dad.
Okay. So although you didn't talk with Charles on the 10th, did you have an understanding of
We're on verdict watch.
what he was going to do the morning of the 11th?
Yes.
What was that?
He was going to go pick up JJ, his son. It was his turn to, I guess, have him for a few days or whatever.
Were Charles and JJ really close?
Yes.
So the morning of July 11th, you were not expecting to get together with Charles at 7 in the morning, right?
No.
Did you get a text message from Charles?
Yes, I did.
And did you learn where Alex was?
Yes, I did.
Where did you learn Alex was?
Alex was at Lori's house.
When you learned this, was Charles texting you sort of in real time as he is coming to the house?
Yes.
Explaining to you what he's seeing and what's going on?
Yes.
And are you responding back to him?
Yes.
Yeah, you can't do an OK counter. Oh my goodness, that would be terrible. The button would wear out.
So you're at your mom and dad's house when you start getting these text messages from Charles?
Yes.
When you learned that Alex was at your sister's, what were you thinking?
I just thought something weird is happening because he never answered my text the whole day I was there, never returned a call. And then all of a sudden he said he's at Lori's house. And I didn't even know what to think at that point. I thought something was off.
So immediately you knew something was off.
Yeah.
From the prior day where Alex ghosted you to now he's at your sister's that morning when Charles was going over to pick up JJ.
Yes.
Were you concerned that Alex was at your sister's house?
A little concerning, yes.
Have you seen text messages that you and your brother-in-law Charles had sort of making the flight reservations and leading up to the morning of the 11th?
Yes.
And were those all messages that you two had as you're trying to figure out how to have this intervention?
Yes.
And then ultimately, what you are seeing and saying that morning at 7:30 in the morning?
Yes.
And I've shown defendant exhibit 210, if I can have a paralegal approach with that. Adam, if you can take a look at those and let me know if you recognize those as text messages that you had with Charles, sort of the 9th, 10th, and 11th, as you are interacting leading up to that morning and including the morning of the 11th.
Yes.
Your Honor, the state will move to admit Exhibit 210 pursuant to 8031 as present sense impressions.
Yes, Your Honor, we object in lieu of that is a report and not the full extraction.
All right, well, may I see the...
So she wants the whole thing in?
That particular objection wouldn't prohibit admission. It would go toward weight. But give me a second here.
The intervention sounds like all the family members around Lori and Chad and everything were really concerned with how
210.
psycho and weird things
And if
were.
I may publish it, then, Your Honor.
Like you guys are way
If I can
way
have the
out
album.
there.
Thank you.
She does have 2 support councils. Like 2 people.
Adam, I'm going to start sort of going back to, in Exhibit 210, the conversations that you and Charles were having as you're trying to come up with a way to have this intervention, all right? So you learned that Charles was reaching out. Well, let me ask you this. You had learned from Charles about this fictitious email, correct?
Yes.
Did you learn that Charles had reached out to Lori about it?
One more time?
Did you learn that Charles had reached out to Lori about this email?
Yes.
Did you learn that he had reached out to Chad Daybell's wife about it?
I think I remember that.
These are text messages. Were you also receiving emails from Charles?
Yes.
Does this sort of array of messages start to involve where you and Charles are talking about having you come out to Arizona to help with this intervention?
Yes.
And so do we see on the 9th you letting him know that you could fly out tomorrow and come home Saturday or Sunday?
Yes.
Do we see as you continued on, he tells you that he could fly you in on Southwest, and he's telling you he's just right now landing in LA, right?
Yes.
And you knew he traveled a lot for work.
Yes.
When we get to the 9th at 9:11 a.m., did you get a message from Charles about how you were going to get everyone together without Lori knowing that you're going to have this intervention?
Yes.
And is that one of the ideas where you indicated that I'll go see Lori at her house and have a talk with her and keep your phone on record?
Yes.
So that was sort of one idea of a potential way to show the stake president that she was having these ideas outside the LDS faith?
Yes.
Does Charles kind of tell you he's not sure that that's really going to work?
Yeah.
He says, I think she'll leave, but it's worth a try.
Yeah.
Did you then suggest also have a family dinner with everyone and then say, always leave my phone on to record what I say and what everyone else says?
Yes.
And then you go on to say that's to have proof for Holmes. Who's Holmes?
President Holmes. He was our stake president, or their stake president.
You were in Wichita, but he was the stake president here.
I lived here before, and he was in my ward, so I know him.
Okay,
So when
a
you're
ward is a
talking about
smaller
the stake
unit,
president,
the stake is a larger
Holmes
unit.
is who it actually is.
Yes.
Okay.
That beep beep is on the judge's computer. It's his microphone picking up his Teams meeting, somebody joining or whatever.
On the 9th, does Charles tell you that got it, but honestly, if you, Zach, Brandon, and me go to him, that should be enough? She will feel like we ambushed her, but something has to be done. She'll be real careful what she says. Had you brought Brandon into this yet? Like, did you have a plan to have him come with you?
No, but Brandon played basketball with us on that night. So me and Zach and Brandon played basketball where President Holmes played basketball at a church. So that was that reference.
Okay. So you thought if we go to the church, Brandon will be there and he can help you
Yeah,
talk about
say
this.
that. Yeah.
Okay.
Fun fact, most LDS
But
churches
Brandon's
have a
not part
basketball
of this
court in
conversation right here, right?
No.
indoor basketball.
Then does it kind of go back to Charles asking for your information so he can make your flight reservations?
Yes.
Okay. Then at 1:13 p.m., does Charles let you know that your flights are booked and that he emailed that to you?
Mm-hmm.
And then does he go on to say, I'm really uneasy about how she will respond, not only to you, but to me and Zach and Brandon, right?
Yes.
It's just a gymnasium.
In talking with
Church
Charles
encourages physical
and this
activity.
intervention, was there a constant concern of how she would respond to trying to take away her temple recommend?
Yes.
Was some of that based upon your understanding of the things she had said to Charles in the past?
That and others. Apparently, Lori was flighty. When Charles tried to serve her divorce papers, she disappeared and nobody knew where she was. So in Charles's mind, that she could be flighty and just take off again where nobody would know where she is. So there was some definite reference to that as well.
Okay. Then it goes on to say, I'll pick up JJ and take him to school. So you knew what he was doing that next morning, right?
Yes.
And you said she'll be there, right?
Yes.
Friday the same. So you knew his idea was he was going to be with his son in the mornings, Thursday and Friday?
Yes.
And then you said she'll be highly suspicious about recording. If you can bring a second device and put your phone on the counter or turn it off, it might help. Is that sort of the same idea that
sneaky?
He was unsure that she would trust you showing up there and trying to ask her about those things?
Yes, this was all just it seemed like Charles was just desperate, and he wanted to do anything he could to, this last ditch effort to try to shake Lori loose of whatever she was under, some spell that he said. So, that's basically what happened.
And then does he go on again to talk about that he really thinks the only thing that's going to break her out of this is going to Holmes?
Yeah. Yes.
And that she's hurting too many families and that he's upset his is gone.
Yes.
Does he say that he still loves her?
Yes.
And does he think that she's basically potentially gone forever?
Yes.
And then we see that he corrected slots to Lori, right?
Yes.
Typo?
Yes. Lots of typos.
On July 10th at 3:34, do you get a text from Charles asking if you're in Phoenix?
Yes.
And do you respond, yes, you're going to Summers, and that you'll call him?
Yes.
And then does Charles let you know he's got a meeting, but he'll try to call you before he goes to see Lo? Who is Lo?
Lo is Lori.
So people would call her Lo or Lolo?
Mm-hmm. Yes.
Arizona is a one-party consent state. Only one person needs to agree to the recording.
Do you remember if you talked to Charles on the 10th?
On the 10th? What day was that?
The day before. So when you flew in, did you ever talk to Charles?
No, I don't remember talking to him then.
So even though you guys had attempted to call, you don't recall if you ever spoke with him that evening or afternoon?
Right.
So at this point, you'd said you went to Summers in the text messages, and then later you stayed at your parents' for the night.
Yes.
And then you knew that Charles would be going to pick up his son the next morning. Did you assume that you and Charles would meet up or talk sometimes later that day?
I figured so.
Okay. But you had no scheduled timeline for that?
Nothing planned.
Okay. So next in Exhibit 210, we see text messages from July 11th of 2019 at 7:35 a.m. where Charles texted you, Al is here. And then just a couple seconds later, he said, at Lori's. Was this shocking to you?
Yes.
And what did you respond back? Did you say, really, I wonder why he never called me back?
Yes.
And then we see that you wrote at 7:36 and 28 seconds, they are planning something. Why did you write that?
Because Alex not answering his phone the whole day and me calling him and texting him, not knowing where he's at. Nobody in my family said they heard from him or knew where he was. All that is very suspicious to me. And then Alex being at Lori's house that morning felt like something was really off.
So when you told Charles they're planning something, Charles responded back, absolutely. Did you then let him know that you were supposed to spend the night at Alex's house? She probably blocked that.
Yes.
Did Charles respond to you, what you do is up to you?
Yes.
So were you kind of upset at your brother for telling you you could stay with him and then ghosting you, ignoring you?
Yes.
Were you upset at him for being at Lori's house when Charles was going there just to pick up JJ?
Yes.
Did you then text him, I'm going to put the pressure on to have him come get me right now, see what he says?
Yes.
Did you in fact text your brother?
Yes.
Did he respond back?
No.
As we're going along here, we see that each of these are being read sort of in this short period of time, these couple minutes that Charles is here as he's driving in, after you texted Charles about putting the pressure on to have him come get me right now, did you then say okay to Charles?
Yes.
And then we see again that at 7:49:34 a.m., you texted Charles, "Me and Zach are going to the Stake Center tonight at 8 to play basketball. Holmes is always there, either playing ball or interviewing people. I will try to catch him and have a conversation with my old friend."
Yes.
What was
Stake
that
Center
about?
is a little bit bigger than
that was
normal
just
meeting
part
house.
of the plan that Charles initially came up with to somehow get in front of the stake president. That night, he's the stake president. He interviews people for Temple Recommends and also plays basketball afterwards. So that was just a thought of maybe this could be something that we could do to help with that situation.
Okay, pause for just a second. So they talk about stake centers and the meeting house. The stake center, we talked about the ward being the smaller unit, like a parish, and the stake being like a diocese. A stake has usually 5, 6, 7 wards in it. There's one building that's called the Stake Center, which is a larger building designed for when all the wards meet together in one meeting, which they usually do about twice a year. So that building is a little bit larger, and that's where the stake president would have his office. So the stake president, they go there, and the larger building usually has a better basketball court. I'm just going to put it out there. It's usually a better basketball court, and hardwood floors instead of that rollout little plastic stuff. But that's why he's talking about that right there.
Now, up until 7:37 and 7, you had been interacting with Charles, right? You would respond and you were getting some text messages back from him.
Yes.
We see after 7:37 where he texts you, "What you do is up to you," that he didn't respond back to any of your other comments, right?
Right.
So when you sent him at 7:37 and 29 seconds that you're going to put the pressure on him, you meant Al?
Yes, Alex.
To come get you. Charles didn't respond to that?
No.
And in fact, it shows that that message was read at 12:13 p.m. versus the earlier messages that were read sort of right in time.
Mm-hmm.
Is that yes?
Yes.
And when you told Charles that you and Zach were going to go to the Stake Center to play basketball and see if you could find Holmes, did you get a response from Charles?
No.
And again, we see that that was read at 12:13, correct?
Yes.
Did you go talk with Holmes that night?
I went to go play basketball, but he wasn't there.
Was it just you and Zach?
Yes.
During the day of July 11th,
Little one-on-one basketball.
at any time, did you learn that Charles Vallow had been shot?
No.
So Lori did not call you and tell you that Charles had been shot?
No.
Alex didn't call you to tell you that he'd shot your brother-in-law?
No.
Anyone in your family talked to you about it?
Nope.
To be fair, that is an
How
awkward
about the
call
next
to make.
day, Friday, July 11th? Did Lori tell you Charles had been shot?
No.
Alex contact you to tell you that he'd shot Charles?
No.
Anyone in your family talk to you about that?
No.
Did you decide to go visit a friend in Tucson on Saturday the 13th now?
Yes.
What were you going down there for?
Going to see my friend Eric.
And did anyone come with you?
Yes, Zach did, my son.
Okay. When you went down there, did you talk with Eric about what's going on?
Yeah, I just thought it was really fishy that I heard from Charles. I didn't know if he took JJ and just was having one-on-one time with JJ. I didn't know if Lori and him were getting back together and Lori told him not to talk to me, or my mind was spinning. Like I had no clue what was going on.
Had you talked to any of your family about it? Were you still keeping that intervention thing secret from them? At that point?
No, at that point, but I think nobody had heard from, I asked if anybody had heard from Alex, and nobody said that they heard from Alex in my family. But at that point, I was there spending time with my son, Zach, also to help Charles with what he wanted to try to get an intervention with Lori, and also to see my friend Eric, because I live in Wichita, so I was trying to do 3 things at one time on my short visit.
So on the 11th or 12th, though, were you still keeping that sort of secret that you and Charles had been wanting to do an intervention on Lori?
Yes.
You weren't telling your family, like, I don't know why we're not doing this.
Charles asked me not to tell anybody.
And was that actually sort of a message you guys had talked about of who in your family might be, might prevent any type of intervention?
Yes.
And who in your family were you guys concerned with if they learned about the intervention might try to stop it?
Mom and Dad, Summer.
Alex, too?
Alex, yes.
So even though you're here and you're seeing your family and you're seeing your son, you don't want to tell them a lot about Charles because you're trying to still keep that quiet in case he does want to go forward with it.
Exactly, yes.
So you're in Tucson and you start talking to your friend about Charles.
Yes.
Do you learn at some point that Charles has been killed?
Yes. I was talking with Eric saying it just, something doesn't feel right. I haven't heard from Charles, and usually he would text me or send me a message or something. And then Eric asked me, he goes, well, what's his last name? And I said, Vallow. And he was on his computer and he just Googled Charles Vallow. And he said it popped up that he's been killed by his brother-in-law.
They found out through Google?
So you learn this. What is going through your mind now?
Just everything, chaos. I had a knot in my stomach. Just probably one of the worst feelings I've ever felt in my life.
Obviously, you had been concerned that something was being planned when you told Charles that on the morning of the 11th, right? But
well,
not that.
Not that, but yeah, it felt like something was off, that why that Alex would be at Lori's house that morning.
Did you know your brother Alex to carry guns with him?
Yes.
Did he regularly go shooting with guns?
Yes.
Okay. Prior to Charles being shot and killed, did you ever tell Lori that you were going to be trying to do this intervention with her?
No.
Prior to Charles being shot, did you ever tell Alex, hey, I'm going to stay with you, but we're trying to do an intervention with Lori?
No.
What about your parents? Did you ever tell them you were going to try to do an intervention?
No.
Your sister Summer?
No.
So if your sister told detectives a couple hours after Charles was shot that she was confronting Charles about you and Charles talking and texting, it wasn't something that you told her about?
No.
You told us that you are LDS. Have you ever taught Sunday school?
Yes.
Can you tell us about the story of Nephi?
Nephi?
Mm-hmm.
Well.
Okay, so now he's gonna tell a religious story. I don't know how well he does on this one. I can tell it for you as well. The reason they're talking about Nephi is that Lori, in her twisted justification for her actions, would take either biblical or scriptural accounts of people in the past who did something that the sort of, and she would shoehorn herself into that story to say, I'm being like, I don't know, everyone knows about Noah. I'm being like Noah, and I'm building a boat. I'm going to sail away. So I'm going to be like Noah. In this case, she chooses a Book of Mormon prophet by the name of Nephi. Nephi lives in Jerusalem, time period 600 years before Christ. Jerusalem's wicked. Nephi's dad says, we're taking the family, we're getting out. And they grab some of their stuff and they go. And then after a while back, they go. Nephi's dad says, hey, God's told me we need to get a copy of the scriptures, which were written on plates, like metal, not like a scroll like paper, but like etched in metal. They called them the brass plates. We need a copy of the scriptures. Nephi, you and your brothers go back and get them. Nephi and his brothers, who are not big fans. The brothers are rebels. Okay, they're like they're always complaining and grumpy. Nephi's the good one. Nephi's the good son. The brothers are bad. They go back to Jerusalem, and they're trying to get the plates from their uncle, who was a guy by the name of Laban. Laban's a rich guy. Nephi's family was pretty well off as well. But they go in, they're like, hey, Laban, we want the plates. He's like, no, those are mine, because they were valuable. And he's like, I'm going to kill you. You're trying to rob me. And so they run him out of town. They try a couple times. Every time Laban says no, the last time they go in, they go back to their house. They get all their precious stuff that they left when they left Jerusalem. They say, hey, look, we'll trade you, Laban. You can have all this stuff. We get the plates. Deal? And he says no, and he runs them out. He takes their property and tries to kill them. So they're out. The Nephi and the brothers are outside of the city, and Nephi's like, look, I'm not going back to Dad without these plates. God told him to do it. We've got to do it. I know it's going to be. There's got to be some way to make this happen. And then the brother's obviously not a fan. Nephi says, I'll do it. I'll do it myself. I'm the little brother, but still, I'm going to make this happen. He sneaks in at night, and he finds Laban drunk on the street. He's wearing his sword and everything else, and Nephi is he feels that God tells him to kill Laban, because it's better that Laban dies and because Laban has tried to kill them and everything else. Nephi kills Laban. He cuts his head off with a sword. And not only that, he then takes the clothes that belong to Laban, puts them on, goes into Laban's house, pretends to be Laban, and says to his servant, hey, bring me those plates and carry them out here. And he gets the plates and they get away. Lori tells this story to say, see, sometimes it's good to kill. We're in Sunday school. Everyone sit down. We're in Sunday school now. So Lori looks at the story of Nephi, and says, sometimes it's good to kill. Thus, it's okay to kill. And in her mind, to do this, she comes up with this idea that people that are in her way, that I think they become dark or whatever, are actually possessed, and they're actually dead already. So they're not really people. So it's not really murder if I kill them. That's what she comes up with. I'm gonna try to fast forward through a little bit and get to the cross-examination from Lori on this, if we can. Give me just 1 second. Let's see if we're on 7. Get to the cross-examination. Let's see, is that right here?
So I was trying to do 3 things at one time on my short visit.
So on the 11th or 12th, though, were you still keeping that sort of secret that you and Charles had been wanting? Did it cause a lot of friction in your family?
Hang on, I'm trying to find a spot. There we go. There she comes up right here. Hang on, we'll get to Kay in a minute. I just want to get Lori's cross. There we go. Okay. Here we go.
Did it cause a lot of friction in your family?
Yes.
Have you started to try to talk with your family some?
Yes.
I have no other questions, Your Honor.
Cross?
Mr. Cox, how long has it been since we've seen each other in person?
Don't know.
When was the last time you saw me?
I don't recall.
So, has it been a year, 2 years, 3 years, 5 years,
Something
6
like
years,
that.
7 years, 8 years?
Something.
Something like that.
Okay. So, you have no idea.
Nope.
You have no idea when the last time you saw me in person.
I don't know the year or how many years it's been.
Okay, so did you see me at Colby's wedding in January 2018?
No, I was not there.
You didn't come to Colby's wedding.
No, I did not.
So did you see me sometime that year at my house
Possibly.
where Colby got married? That house.
I did see you at that house, yes.
At least one time.
Yes.
So possibly in 2018.
Yes.
And when was the last time we had any communications?
The last time I remember our communications was you and I were speaking in the kitchen when the family was over.
Okay, so you think that was that time in 2018?
I think so.
Okay. And were we eating my green chili chicken enchiladas?
Do not remember that.
You do not remember that?
Nope.
Is that what I made every time we had a family get together, which was like 10 times a year?
I don't remember
Got
that.
one dish. Make it every time
And
we
when
get
was the
to. You
last
don't
time that we
remember
had a phone call or
my
text
enchiladas?
message?
I have no idea.
Could it possibly be around that
green
exact
chili
same
ones.
time?
Possibly.
Okay. So that was
I'm
possibly
gonna
in early
rewind. I'm gonna rewind.
2018?
Pause.
Yeah.
Pause. We're going to rewind just a little bit here.
Was dark.
Sorry,
Objection. Calls for hearsay.
It's whether or not he was aware of it
I went too far back.
and had Googled and learned that Charles was.
I'm so bad at this, guys. I suck at rewinding.
Did your son go with you this time?
Okay. There it is. It's before this, just a little bit.
We haven't spoken in about 8 years. Would that be correct?
Just before this, almost there.
Okay. So that was possibly in early 2018?
Here it is. I'll be quiet.
Yes.
Listen.
Okay.
Did I
Who do you think initiated the final
I just barely missed it.
sometime that year at my house
This is it. Okay, last time.
Possibly.
where Colby got married? That house.
I did see you at that house, yes.
At least one time.
Yes.
So possibly in 2018.
Yes.
And when was the last time we had any communications?
The last time I remember our communications was you and I were speaking in the kitchen when the family was over.
Okay, so you think that was that time in 2018?
I think so.
Okay. And were we eating my green chili chicken enchiladas?
Do not remember that.
You do not remember that?
Nope.
Is that what I made every time we had a family get together, which was like 10 times a year?
I don't
It's bigger
remember
than
that.
you.
Okay.
It's bigger than me.
And when
It's
was the
bigger
last
than
time
all
that
of
we had a
us.
phone call or text message?
Okay, I'm sorry.
I have no idea.
I
Could
need
it possibly be around that exact same time?
Possibly.
I need the recipe. You know we need it. Can somebody find me the recipe? I'm usually not a big fan of green chili. I'll say this out front. But apparently everybody remembers Lori's green chili enchiladas. Green chili chicken enchiladas. Oh my goodness. I need like 2 pans of them. 1 pan will not be enough. If somebody has the green chili chicken enchilada recipe that they can maybe just text me on the phone, I need to know. And I mean, I need to know everything. I need to know the size of the tortilla you use. Do you pour a layer of sauce first, then insert the tortillas, then a layer on top, and then grated cheese, or is it like just put the tortillas in, right in the pan and then do a pour over with the extra enchilada sauce? All these things are crucial because however she makes it, sounds good. Do you like green Jell-O with shredded carrot? Yuck, yuck. That's a terrible combination. I don't even like Jell-O. Megan Connor, Lori Vallow cousin gave the disgusting recipe on our channel. Can we do like just an enchilada, chicken enchilada instead of the green? Can we? I don't like the green look. Many different types of sauces. On Colby's YouTube channel, he said the ingredients came from cans. You didn't try my signature Heinz 57 baked beans? She opens a can and calls it her secret recipe. Oh my goodness. What is the phone number? The burner phone is 801-521-79. No. 801. I have lots of numbers in my head. 801 513-1160. There you go. That's it. I got it. That's the burner phone. I think I was trying to give you a combination of my Social Security and the burner phone number. The 801 was pretty good. All right, the recipe's incoming. Wait for it. Do we need to watch the rest of this, don't we? I'm sorry, I paused it and I got lost.
So that was possibly in early 2018?
Oops. Keep going.
Okay. And when's the last time that we had a phone call or text message?
I have no idea.
Could it possibly be around that exact same time?
Possibly.
Okay. So that was possibly in early 2018?
Yes.
Okay.
I think the jury needs to sample the enchiladas. It's like a juror review, but it's a taste test.
Who do you think initiated the final communication in our relationship?
Who concluded it?
Yeah.
I don't know who started it, but I know who finished it.
I don't know.
So right now it's 2025, is that correct?
Yes.
And so we haven't spoken in about 8 years. Would that be correct?
Probably 7 or 8 years.
Okay. So would you say up until that point that how often would we communicate before that?
Love Hatch green chilies.
Before what?
Those are good.
Before 2018?
Probably on a regular basis. Once a month, twice a month, 3 times a month.
Like a call or a text message?
Yes.
Just keeping in touch?
Yes.
I'm getting so
You know
many
of us
recipes
living
right now.
in Hawaii and you were living in Kansas at the time?
Yes.
Was that a brag? We were living in Hawaii.
And in your
were
career, you
Kansas?
lived in lots of different places, is that correct?
Yes.
Austin,
Yes.
Dallas,
Yes.
New York,
Yes.
Wichita,
Yes.
Sacramento.
Yes.
Did I miss anything?
Yes.
Others?
And I was in Texas,
Yes.
Arizona.
Are we like
Hawaii?
bragging, showing off each other's passports?
So would you say that we were not physically close during the past 20 years?
Yes, I would say that.
So our communication would be solely family get-togethers, occasional text messages. Is that correct?
And phone calls, yes.
Okay.
Can someone get me the actual recipe that Lori uses? I would make it. I would make it on a live stream.
So, Mr. Cox, did you see or hear or personally witness me conspire with my brother Alex Cox to murder my husband Charles Vallow?
Repeat that again?
Okay. Did you see with your eyes or hear with your ears
or vice versa,
or personally witness me conspire with my brother Alex Cox to murder my husband Charles Vallow?
No.
Thank you. No more questions.
The way you say it, no.
Redirect?
I've got a lot of texts with recipes. They're coming fast. Faith, I got your text as well.
Have you talked to your sister since Charles was shot and killed?
No.
So, since that happened, you cut off all communications with her?
Yes.
Prior to that, you were being asked about 2018 being at Lori and Charles's house. Was that the time where Lori told you she was becoming a celestial being?
Yes.
And the time where she was telling you other ideas that were not in line with the LDS faith?
Yes.
Is that like ascending in Stargate?
After you had heard those statements by your sister, you told us that she had asked you if you thought she was crazy, right?
Yes.
And you had responded back how?
I don't know if you're crazy, but what you're telling me is not true.
After you told her that her beliefs were not true, did that sort of end your talking with her?
Yes.
You were asked if you personally saw, heard your sister Lori conspire to kill Charles. Were you there that morning?
No.
Were you the person who was supposed to, though, be with Alex on the 10th into the morning of the 11th? You spent the night with him?
If I would have spent the night with him, yes.
So that stood out to you
Guys. Sorry, get my shopping list.
because you had made plans with your brother, right?
Yes.
Give me a second to get my shopping
And
list.
instead, you learned he was at Lori's house.
Yes.
You told us that you thought it was odd that your brother would be over at your sister's house at 7:30 in the morning.
Yes.
And you were aware that your brother had guns.
Yes.
Charles was going there to pick up JJ, right?
Yes.
And so, did it seem odd to you that your brother would bring a gun that was loaded with extra magazines that was not safe to your sister's house where JJ was?
Objection, out of scope. This is not just
Goes to the
a
conspiracy.
redirect. This is not just a redirect.
Hey, I didn't ask for argument. Okay. The objection's overruled.
What's the question?
Sure.
The verdict is in the other
Did it stand out
trial
to
we're not
you
following. That's in the
that
celebrity
your
murder
brother,
trial.
who knew JJ, would bring a loaded gun and extra ammunition to the house where JJ was running around?
Well,
It wasn't-
I didn't know at the time.
Yeah.
You're saying afterwards?
Yeah, you learned afterwards your brother killed him, right?
Yes.
And when we're talking about this conspiracy and things that are going on, did that seem odd to you that your brother would bring a loaded gun and extra ammunition in an unsafe way to a house where your sister's son, JJ, lived.
Yeah, it seems extreme.
When you were talking to your family after this happened, did you actually tell them that you believed that Lori and Alex had conspired to kill Charles?
Yes,
Why was that?
because Lori had told people that Charles was no longer living, that some guy named Ned was inside of his body, that there was a zombie living inside of him.
This is like Men in Black
And
Club.
Alex didn't respond to any of my text messages when I was supposed to be with him. And he was at that house that morning. Lori talking crazy about how she's a translated being. All these things all added up into that moment and that morning. Once I found out on Saturday that Charles was shot and killed, no doubt in my mind that they killed him. That's a feeling that I got.
And you told your family that?
Yes.
No other questions?
The last line of questioning from the possession of the gun on, I think the defendant's right, was technically beyond the scope of her cross. So based on that, I'll allow the defendant, if she wants to recross on those issues, if she elects to, may do so now.
Okay. Beth, can I share your recipe online? Because your recipe sounds more like a recipe than anything else. If it's your family recipe you've just shared with me, I don't need to publicize
No questions, Your Honor.
All right. Are there any questions from any member of the jury? Not seeing any, sir, you can step down. You can step down. Thanks. State can call its next witness.
Thank you. If I may go get her.
Go ahead.
Okay. I think to actually make the green chilies, I make them absolutely the green chili enchilada. What green chili chicken enchilada recipe? I'm going to have to buy some seasoning because I'm all out of flat iron pepper seasoning, which is my favorite. Let me do a little shopping. It is the best pepper seasoning known to man. Okay, flat iron pepper flakes. They have a Hatch Valley Green premium chili. Oh, this is going to be it right there. Mrs. R.A. has already made the shopping list, and I need to amend it really quickly before she goes. Here's what I'm getting. This is the seasoning I want to add. I realize it's already. This is the link to the seasoning affiliate link, just for the warning. It's the best pepper flakes ever. The flavor of this, it explodes your mouth, and it's not too hot. I want to order those. Beth suggested I use rotisserie chickens to just get really well, cooked and tender and flavorful chicken. I'm gonna one up Lori. Is what I'm gonna.
All right,
do.
you're gonna
remember
up here.
my green chili recipe.
My clerk will swear you in. You're gonna stand right here.
The whole truth, and nothing but the truth, so help you God.
You're going to walk around the court reporter here and have a seat just to my left.
We've passed 3 hours and 15 minutes of deliberation in the Michigan versus Linda Stermer trial. It's up in the top corner. You can see the counter going there. I know the flags sort of blend together, but that is picture in a picture for you. It's not too hot, says the man who drinks hot sauce out of a bottle. I could live stream it. Let me pull the trigger on this chili really quickly. On the
Thank you. Would you please introduce yourself to the jury?
My name is Serena Sharp.
I'm going to have you pull in a little or move the mic down a little closer to you so we can hear you. Thank you. How old are you, Serena?
How old am I? 51.
Is this the one we're supposed to watch?
Where are you living currently? What state? What city?
Arizona, Queen Creek.
And where did you live back in 2019, 2018?
Connecticut.
Okay.
Connecticut?
When did you move to Arizona?
It was right before COVID, so 2019.
Do you recall? I know we don't have a lot of weather here, but summer, winter, fall.
Definitely summer. This is hot. I think it was end of July, August, but we closed on our house September.
Are you a member of the Church of Jesus Christ of Latter-day Saints?
Yes.
Were you raised in this church?
Yes.
Do you consider yourself a spiritual person?
Yes.
I want to talk to you about a group, Preparing the People. Have you ever attended any of their events?
Yes, two.
Can you tell us
Who's
what
that?
those are?
I've not heard of them before.
They were conferences that helped people prepare physically and spiritually for emergency preparedness and the second coming of the Lord.
And you said you attended a couple of those conferences?
Yes.
Are they located sort of around the country?
Yes.
So we're talking like food storage
one of those
and
conferences
spiritual
here in
study?
Arizona?
I did.
Do you recall when that was?
It was November of 2018.
When
Let
you
me
decided
pause
to
for
come
just
to
a
this
second.
conference,
Pause. Sky Mama says, is this mainstream Mormon stuff? The belief that Christ will return to the earth is extremely mainstream. That's mainstream Christianity. The preparation is the idea to prepare for that time is also basic Christianity. You're trying to be a good person. The idea of some of the preparation is food storage and prepare temporally for it is probably more strongly pronounced in the LDS faith than many others. But it's very common. It's basically an extension of the idea that everyone should be self-sufficient and not rely on each other. It's if you go back to the Bible, there's a parable that's taught in the Bible about a wedding and the women that were waiting to meet the group as they came to the church, and half of them had enough oil and half of them didn't. And the idea is that when the wedding happens, the people that had enough oil, who had saved up enough for when the wedding party showed up, they were invited into the feast, and the ones who had not prepared in time were still out trying to scramble and get oil, and they weren't invited in. So it's that idea encompassed around basically the culminating event of the doctrine, which is that Christ is going to come again to the earth. So it's talked about in this food storage and preparation. But when you get to some of these groups that are Prepare the People, this is not the church. This is not the LDS church is putting on these presentations. These are groups within that might be focused on a narrow portion of the belief and sometimes hyper-focused on that. And doing it on their own, but they would clearly advertise to members of the church. So it would be mostly members of the church who are present and participating, and it would be common to have terminology from the religion, wrapped up in everything they're doing, scriptural teaching, leaders quotes and things like that from conferences and speeches they gave, all wrapped up into that same thing. But oftentimes it's commercial, and they're either selling a product. They might be selling food storage in 5-gallon buckets that will last for 100 years or something like that, or I don't know, shotguns. I don't know what else. I've never been to one, so I'm not sure what else they sell. So sort of mainstream, but can get very fringy very quickly.
in November of 2018, did you know anyone here?
2 people One just from over the phone conversations, Melanie Gibb and Jason Mao.
So, did you have any place to stay when you came here? What was your thoughts as you're coming in for this conference?
Both of them invited me to stay at their homes.
And what was your plan? Who did you think you were going to stay with?
I thought I was going to stay with Melanie Gibb because she offered to pick me up at the airport as well, so that I didn't need to rent a car.
Did you know Arizona well?
Not at all, no.
So were you picked up by Melanie Gibb?
Yes.
And did you stay at her house?
No.
Where did you stay?
After she picked me up, she said that instead of her house, because her whole family was home and it was busy and chaotic, we were going to stay at her friend's house, whose family was gone for the weekend and had a bunch of people for the conference staying there.
Okay. Who was that?
That was Lori.
Did you know her last name, or did you learn it?
I learned it when I got there. I had never heard or had met her before.
What was her last name?
Vallow?
Okay. So you told us you didn't know Lori Vallow prior to just coming to stay at her house.
No.
Do you see her in the courtroom today?
Yes.
Can you point her out and tell us what she's wearing?
She's right there with glasses on and blonde hair and a black jacket.
Your Honor, may the record reflect the witnesses identified the defendant.
It shall.
Do you recall who else was staying at Lori's house that weekend?
There was a lot of people, and I was meeting everybody for the first time, so I don't recall everybody, but I do know Lori was there and Melanie was there.
Did you ever meet Chad Daybell?
Yes, he was there as well.
Was that the first time you met him?
Yes.
So during this event, are you going between Lori's home and to a location where the conference is at?
Correct.
Okay. And did you ever talk with Chad Daybell outside of, well, did you ever talk with him that weekend?
Yes.
Okay. Did you ever talk with him after that November 2018 conference here in Arizona?
Yes.
When else did you see or talk with him?
I saw him at another Preparing a People conference in February.
So that's 2019 now?
Yes.
After the November one?
Correct.
Where was that one?
That was in Idaho.
And did you ever contemplate moving to Idaho?
Yes.
Did you ever meet with him in Idaho did you learn he lived there?
Yeah. When did I learn?
Did you learn that he lived in Idaho?
Yes.
And did you ever, in fact, meet with him in Idaho to kind of talk about possibly moving there?
Yes, I was actually house hunting with a realtor and in the city that he lived, so we connected for a few minutes.
What city was that?
Rexburg.
That's where BYU, Idaho is.
Did you know if Chad was married at that time?
It's a windy, cold place.
Okay. When you were staying at Lori's house in Phoenix in November of 2018, did you understand her to be married?
Yes.
At that time, did you have any idea that Lori and Chad were having an affair?
No idea.
After you met Lori at this and stayed at her house, did you have any more conversations with her, texts or phone calls?
Yes.
Were you ever invited back out to Arizona?
Yes.
When was that?
That was in March of 2019 for a girls' weekend.
It's the fishing,
What was the
Kathy.
girls' weekend going to be?
It's got great fishing.
It was a few girls coming together for a girls' weekend, so
Whose house, where was it going to be?
That was at Zulema's house, and I think from my memory, she's the one who invited me and started that girls' weekend idea.
Had you met Zulema before?
Yes.
Where had you met her?
I met, it's vague, but I think I met her at the first Preparing a People conference I came to, which was the November 2018 here in Arizona.
Okay. And had you talked with her as well between that November time and when you came out in March?
Yes.
Who else was part of this Girls Weekend that you recall?
It was Lori and Melanie Gibb, Zulema, Christina, Nicole, and myself. I think that's it.
Okay. Now, were all of you women members of the LDS Church?
Yes.
During this time, did Lori ever tell you things about her beliefs that seemed to go against what you understood or what you were taught through the LDS Church?
Yes.
Did Lori ever tell you that she did not need to repent?
Yes, she did.
What does repenting mean?
Repenting means turning to God and confessing our sins and repairing our relationship with Him so that He can take on our sins for us and we can become better people through Him and seek His forgiveness.
Let me pause for just a minute. The basic idea in the church about repentance is that we all make mistakes every day and we're trying to become better people. And repentance is the process of recognizing those mistakes and making the changes to improve and be better and become ideally more like God so that, you can, so you wouldn't feel out of place if you went to live with Him. That's the idea.
Do you recall what Lori told you about not needing to repent anymore?
What I remember is she's had a couple of verses in the Bible that she pulled out and read and then said, I believe something to the effect of, I believe we don't need to repent anymore.
Did that stand out to you?
Oh, yes. Yeah.
Was that
was
concerning
shocking.
to you?
Pardon?
Was that concerning to you?
Very.
I think you just said you were shocked by it.
Yes.
It was that against your religion.
Does it show?
Did she ever express to you and this group that all of you might not need to repent?
I don't remember the specifics of it. If she was trying to apply that to us or just to her, I don't remember. I just remember she said we, or generally, I don't remember the specific words she used, but that there was not a need for repentance anymore.
Do you recall, have you been interviewed by the police a couple different times?
Yes.
Do you recall being interviewed in April of 2021?
Was that was the Chandler Police
At
Department?
the police department instead of at your home? Yeah. Do you recall saying to the detectives then that she said, we don't need to repent anymore. We've come to that stage. And then you were asked when she said we, was she talking about like her and Chad or all you guys? And you said she was trying to get all of us to believe that.
Mm.
You recall saying that?
I don't recall saying that, but if that's in the transcripts, that was much closer to the time when it was said. It's been a few years. I don't remember exactly what was said anymore.
So your memory back then would have been better than now?
For sure.
So if you had told the police back then that she was trying to, in fact, tell everyone that you could follow along with this belief of not repenting, you would have been truthful to the police back then.
Of course, yes.
Do you recall Lori ever talking to you about people having dark and light levels assigned to them?
Yes, I do.
And do you recall Lori ever talking about not needing to repent because she was translated?
I don't remember her using that specific word, but not trying to.
Okay, it's time for a pause. Time for a pause. Okay, couple things. Dark and light levels assigned to them. I know about this from Chad's case. I think she's trying to talk about some sort of an aura, like a spiritual, something that's not physical. Like it's not just we're not grading skin color here. We're looking at they have a spectrum of some sort that only certain people can see. This is completely foreign to me. I have no idea about this. Orbs, maybe? I don't know. Could be orbs. And you get that is what she's going to incorporate into her ability to sense when someone is dead so they can be killed, like Ned or Charles. It's some weird stuff. And so she's wrapping in the idea that we don't need to repent, meaning basically everything we do is right. I can make just determinations myself, a lot like, say, God would, about whether someone is good or bad. Judging someone, and it's a little. The alarm bells would be ringing for someone who was an informed member of the Church of Jesus Christ of Latter-day Saints, that these discussions are not just deviating, but literally going in reverse from a lot of the common beliefs of the. Hey, Miss Sorry, how you doing? You got me some snacks? We're in the middle of Lori Vallow. We're on Vertical Watch. 3 hours, 34 minutes so far on that. I forgot what the last thing she said was. Hang on one second. What was the last thing?
I don't remember her using that specific word.
No, it was before that.
You would have been truthful to the police back then.
Of course, yes.
Do you recall Lori ever talking to you about people having dark and light levels assigned to them?
And translated. Hang on
Yes,
one
I
second.
do.
And do you recall Lori ever talking about not needing to repent because she was translated?
Okay, pause. Translated. The idea about translated is that on Earth we have mortal bodies that can die, that there will be a death and a resurrection, and you will have an eternal body which cannot die. So that your spirit and body are rejoined after death through resurrection, and you live forever in whatever kingdom you just, heaven or hell, go wherever you fit. That's the idea. Translated in the term that she's using it is referring to the idea that there are a select few like a rapture, like instantaneously switched from the mortal side to the immortal side without having to go through the whole death, burial, and resurrection. So she's saying basically that I'm still alive, mortal, but really this is celestial me. I'm like a god. Here, Mrs. Aria wants to talk.
I want to add something really deep and thought-provoking, is something that's going to really make you guys
Can I eat the snack you're holding?
Here it is. When I watch the interaction between Lori and this lady, I want to punch Lori in the throat. That's it.
Then she can repent later. That's a bad
Maybe.
thing.
I don't know that that's really a repentance thing. I feel like that is the appropriate response to the way she is treating her. I'm never going to fit in with the soft-spoken sweet ladies, but man, I'm going to punch the mean ones. That's it. That's all I have to add.
Don't make my wife mad. She'll punch you right in the throat. Thanks for the snacks. Appreciate it. All right. Helen Lewis, thanks for gifting 5 memberships. Appreciate that. Let me go back. I'm falling behind. Okay.
I don't remember her using that specific word,
I have
but
to speed things up.
I'll turn
Throat punch. Man.
What do you recall her
They're
saying with
dried
regards to
fruit
that?
nut mix.
I remember her talking about changing physically and spiritually. Those are the 2 I remember.
And by changing physically, what do you recall of that?
Just being filled with more light and knowledge so that we could become closer to God.
So is that sort of the same as when we're talking about being translated?
Yes.
Okay.
I just don't remember her saying that specific word.
Okay. So the concept was the same, whether or not she said that word, you don't recall now.
Correct.
Me too.
Did Lori ever talk to you, either that weekend or prior to that, about casting?
Yes.
Oh, fishing. I'm really good
Do you
at casting.
recall if Lori was the
cast
person who brought up
100
casting?
yards with a good lure.
I believe she was, from my memory.
Do you recall if she talked to you about casting on more than one occasion?
Yes.
Not fishing.
Now, how many times do you recall that she had brought this up?
I don't know how many times.
It was more than once?
Yes, it was more than once.
I think that's what they're referring to.
Did she ever bring it up while you were talking or Zoom talking like we used to do in the pandemic?
I never Zoom called with her. I don't.
Phone call?
Phone calls? Yes.
So at least one phone call you recall that she brought up casting?
But I remember one phone call. There might have been others. I just don't remember.
So was that phone call, to the best of your memory, before this girls' weekend in March of 2019?
I love that. That's
From
awesome.
my memory, I think it was after. But
So then let's talk about the weekend of March, the girls' weekend in March of 2019.
Okay.
Did Lori bring up casting there?
Yes, she did.
Thank you, Virginia.
And the other time when Lori had talked about casting, whether it was before or after, was this to sort of cleanse society, sort of a generic, I don't want to say generic, but to try to cleanse evil from an area or a population, not a specific person?
Yes, it was like generally a cleanse or casting out evil.
Have you on your own sort of prayed to get rid of evil?
Yes, I have.
Is that sort of a personal casting that you've done? If we want to term it that way.
Yeah, I wouldn't term it that way, but yes.
Okay. Would you just term it as you're praying for the better of the world?
Praying and or casting out evil. Yes, in the name of Jesus Christ.
But you said you had never used casting as a term before.
No.
The idea behind this is that, and I can explain it best with the scientific principle, is that light and dark can't exist in the same place at the same time, right? Either there is light or there is dark. If there is light, displaces dark, and so the idea that if there's a bad feeling or something, you replace it with good feelings, and it pushes it out. So the terminology is strange. I'm not sure where they're getting this and what they're exactly going to, but interesting.
So Lori was the one using this word casting.
I don't recall her using that word. I think she was also saying casting out from my memory.
So casting out.
Mm-hmm.
When you met up on this girls'
I'm
weekend.
sorry, was the last answer a yes?
This was the first, I guess, Lori was the one using the term casting out.
Yes.
Okay. On this March girls' weekend trip.
Yeah, I think that's the closest
Do you
what they're
recall
trying to talk
having Lori ask everyone to help cast out as to a specific person?
Yes.
Can you tell us who that was?
It was her husband, Charles.
Had you ever met Charles before?
Vague memory, but it was a quick, I think, meet as I was leaving Arizona for the Preparing a People conference in November. I was going to the airport, and I think he was coming in at the same time. Again, it was pretty chaotic.
Yeah.
But I think that's when we met very briefly.
So he was kind of coming home and you were leaving.
Yes.
Okay. Did this seem unusual to you to do this, to be asked to cast out as to a specific person?
Yes. But not. Did you say unusual?
Yeah, did it stand out to you, her asking you to cast out as to her husband?
Yes, it stood out to me.
During this weekend, did Lori talk to you about her husband, Charles Vallow, being possessed?
Yes, she did.
What do you recall about her talking about her husband being possessed?
I recall that she spoke about her husband being possessed by an evil spirit, and she named the evil spirit.
Do you recall what the name was?
Yes.
What was it?
It was Ned.
N-E-D? Ned?
N-E-D.
How did you choose that name?
When you heard this, did that stand out to you as well?
Very much, yes. Very unusual.
Are you someone who questions things? Or
Yeah.
do you just go with the flow?
I question things.
So you're hearing these things from Lori that are standing out to you, some of them very against your religious beliefs. Are you starting to ask about some of these things?
Yes. I remember I was asking a lot of questions about the repentance thing she brought up. And I remember asking and talking to some of the other ladies about the casting out in a group setting before.
Okay. Pause question. Good question here, Allie, sorry. Is the preferred term LDS or Mormon? The long definition of this, Mormon is the name of another prophet who was instrumental in putting together what is the collection of records known as the Book of Mormon. That's why it's called the Book of Mormon. He compiled everything together. So Mormon was actually a slang term given to members of the church because of their belief in additional scripture beyond the Bible, the Book of Mormon. So LDS, Latter-day Saints, is a short version. The church prefers the long name, which is the Church of Jesus Christ of Latter-day Saints. And so they've actually done a lot of, I guess you call it rebranding, over the past few years to make the name of the church be the full name. So they have a world famous choir. The Mormon Tabernacle Choir is what it used to be called, but now it's the Tabernacle Choir at Temple Square. Temple Square being the building, the location where they sing from. And they've just rebranded a lot of things that way. So they, in like the style guide, if you were a reporter reporting on something that involved the church, the official AP style guide would recommend that you use the full name of the Church of Jesus Christ of Latter-day Saints, on the initial time, and then on future references you can refer to it as the church, or I believe sometimes the LDS Church would be acceptable in style as far as reporting goes. But great question.
Or stuff like that.
Do you recall Lori Vallow telling you that her husband Charles was no longer Charles, that he was now this possessed person?
Yes.
When Lori was talking to you about Ned,
Was she explaining that this evil spirit was now in the body of her husband?
I don't know if she used those exact terms, but that was the impression I got, yes.
So the word she used expressed to you that idea that this evil spirit Ned was now in her husband's body.
Yes.
So did you ever hear Lori use the term zombie?
I did.
Is that another thing that kind of stuck out to you?
Very much.
It is very,
In
very
listening
strange.
to
It's something
Lori,
from the
did
movies.
zombie sort of come to, did you understand that to mean someone whose body was possessed by an evil spirit?
Prior to this, I had thought zombie was like a Hollywood thing, but she tried to relate the zombie and correlate that to the evil spirit that was inside of somebody.
Like her husband?
Like her husband, yes.
It's a weird thing.
Did you
Sorry, I'm missing a
ever
lot of
start
chats.
to question Lori about zombies and these evil spirits inhabiting her husband's body? Did you try to question her about that?
I don't recall specifically.
I'll ask him, Kathy, just for you. I'll see what we can do.
When you started questioning her, at least about repenting that you recall, did you see a difference in how you were treated?
Soon after that girls' weekend, yes.
So let's talk about the group casting. What happened? What did you guys do for this group casting for her husband, Charles?
All the ladies came together and we were all in the same room just talking. And I remember coming together. I don't remember if we were standing or sitting, but I remember Lori started and asked for this help for her husband because she needed to cast out this evil spirit.
Ned.
And she asked to just go around the room and each of us take turns casting out to see if we could get rid of this evil spirit within him.
Ned.
Strange idea.
Ned.
To me.
And this was the first time you'd ever had anyone ask you to be part of some group to cast out?
Yes.
And a group to cast out a evil spirit as to a specific person?
I've never done that in a group setting before.
Yes.
That was,
It's
never
always
even heard
just
of that
good
before.
things. I think there's a hyphen in there somewhere.
After this weekend, let me ask you, how many days do you recall that you were here?
For which?
That March?
That March?
Yeah.
Just a couple days. I don't recall how many. Just a couple days, though.
Okay. So
Like a weekend, maybe?
just the weekend type of thing.
Approximately.
During that time, do you recall just the one evening where Lori had asked you and the other women to cast out this evil spirit and her husband? Was there just one incident that weekend that you recall?
One incident. I'm sorry, I don't understand the question.
Over the March Girls Weekend, was there just the one time where Lori asked the group to cast out Ned from her husband?
From my memory, yes, I think so.
Had you heard on, though, more than one occasion, Lori saying that her husband was possessed?
More than one occasion on that weekend, or like?
Or either that weekend, or had you previously heard that?
I don't recall previously hearing that. And I don't remember hearing it after how many times she said that.
Was it discussed throughout the weekend?
It's time for another pause.
I believe so.
Pause. Kathy says, what about the We Are Mormons billboard in Times Square a few years ago? The church has done a couple Times Square billboard ads. It's true, very much so. The name Mormon was very commonly accepted, and I would say widely accepted and used at virtually all levels of church membership through leadership and everything until just a couple years ago, when the leadership of the church asked that we change the discussion about that and bring back the focus that it's called the Church of Jesus Christ of Latter-day Saints, because it's removing the name Jesus Christ from the church, which is central to the church teaching. So, yeah, all the Mormon Tabernacle Choir, everything that was talked about Mormon, except for the Book of Mormon, which is just the title of the book, that stayed the same. But the discussion, the website, the church website, which was like mormon.org or something like that, all that changed, and now you have to type out the whole website, the Church of Jesus Christ of Latter-day Saints.org instead of mormon.org. I think it probably still redirects, but it was a recent shift for the purpose of putting the focus back on Jesus Christ. That's why. Okay, we're back.
Let's go ahead and recess for lunch.
I could have waited 3 seconds.
We'll resume
and I would have
at
had a lunch break.
1:30 p.m. I'll tell the jurors to remember the admonition.
All rise for the jury.
Key Sunsets, if it's not clear, I very much am LDS. I'm active LDS. I love it. I don't think YouTube is the best format to have a religious discussion. I think with my YouTube, I don't preach on here. I don't like teach and try to recruit or anything like that. I think the best thing I can do is just be the best person I know how to be, and that's what the focus of this channel is. So that's why we do it. I have some information. I can help clarify this particular case. That's why I'm answering. So if you have questions, I'd love to answer them there. But some of you figured it out when I told you I have 10 kids in 10 siblings. There are 10 siblings in my family, and I was raised in Utah. But yeah, Pickles, not politics nor religion. We'll put them all there. Anyway, this is a fascinating case as we go back to now waiting for the state of Michigan to come around. We're approaching. Well, right now, let me check. Yeah, we're 3 hours and 54 minutes. So just about 4 hours. We have motion in court. There are 2 people that just walked in court. Oh, that's the wrong court. Sorry. Oh, man. I thought we were in this one, and no, we're not. Okay, so we're 4 hours in. No sign of anything. 0 juror questions out of Michigan. Let's see. I love that, Saturated Daily. I think that's what matters. Okay, let me just say, just personal belief here. I think a lot of, let's say people in my church. I think a lot of people in my church will be surprised at how many people in other churches are there in heaven because they just led good lives. I think that is a huge portion of what matters. Just be the best you. Be the best you. Treat people nicely. It's not that hard. Try not to kill people. Linda Stermer, Lori, try not to kill people. Do better. Make better enchilada. Anyway, so we're back. Don't do crime. Try. Hey, it's a process. Kathy, you can always repent. Just try not to kill people. What is the talking rabbit? I don't know what the talking rabbit is, Josh. I don't know what you're referring to. Is there a verdict? There is not a verdict yet. We are going to go to lunch yet. Here's the sad news. I've told you I want to make Lori Vallow's epic chicken enchilada. Green chili chicken enchilada. I forget what it is. Her recipe. I want to do it better. I'm going to do one better. I'm going I'm going to start with Sam's Club rotisserie chicken, which is the top. You can't get better than that as far as the meat is concerned. I've ordered the Flatiron Pepper Company Hatch Valley green chili pepper flakes for seasoning. I think I have to order the finest cheese. Is it cheddar cheese you put on it? People, I've got all these recipes and they're like, combine. I need exact measurements. I need to know what she does and how to make it better. And we'll see if we can do a. I don't have a Costco around me. I didn't know it was Zapped. I've talked to Ari about this for over a year off stream. Yeah. I don't make it a point on my stream. This particular case brings it out, and it won't be a point going forward. But Laura used cream cheese. I'm gonna have to use cream cheese, a brick of cream cheese. But what about like on the top? Don't you put some sort of melted cheese, like a cheddar or something? Somebody's calling in. Hang on, let's take a quick call here. Don't think it's a prank.
Call from
Master Ayden.
Hey, Master Ayden. This is Scott. How are you doing?
So, how you doing? So, if the rumors are true, people who know the law know how to cook as well.
I don't know.
We're going to get a cooking segment from RA.
She talks about this green enchilada, whatever. Was it a
Yes,
casserole?
I've had that. Yes.
Is it?
Yes, my it's very good.
Okay, I'm going to do it better. I'm committed.
Okay.
I'm going to use the best ingredients, and I'm going to take the most careful care in preparation. I'll hand pick the rotisserie chicken myself, shred it so that all the bites are perfect size. No too large chunks where you don't get the right mixture of flavor and everything. But I do need a recipe to sort of guide me because I have no clue when it comes to that.
Right. Do you have a chef hat? I feel like you have to have a chef hat and an apron that says "Cooking with RA" on it. I just feel like that's a must for some reason.
I don't have a chef hat. I only have Mrs. RA's apron, and it says "Kiss the Cook" on it.
That'll work. That'll work.
I'll wear that. I have to use the extension ties because it doesn't fit around me like it fits around her. But
I got you. Okay.
Pepper jack cheese. I'm okay with making it a little spicy.
Well, see, the mother of my children, she made a 4-cheese green chili chicken enchilada medley, and for the life of me, I got fat that day.
What are the other cheeses? You got mozzarella and cheddar. Those are our basic.
Right. Pepper jack.
Pepper jack.
And then
cream cheese.
Cream. Yes, that's what she used. Cream cheese. Yes, she used cream cheese.
All right.
Cream cheese, yes. I don't know how she did it. I'm not allowed in my kitchen, so I mean,
I don't think it's cottage cheese. Mrs. RA, fun fact. I should let you know. I just ordered something on Amazon. It is pepper flakes.
You tell her after you do it.
Yeah, so the pepper flakes will arrive in a couple days. We're going to do a live stream. You're invited, Jen, to come and participate and maybe help stir. But we're making Lori Vallo's recipe.
Yep. Is this going to be an ASMR kind of thing where you get to hear the chopping and you have that good mic and you can hear all the,
I was going to use like the salad shooter that you just stick stuff in and put the button and it goes and it chops it for you. Is that cheating?
Okay. No. And you got to do it in a very low tone Bob Ross voice when you do it. Kind of, really get the cooking mood in.
Okay, I will.
Yeah.
I'll do my best.
Yeah.
Here. Let's see.
I'm on YouTube. We talking to my green chili. Oh. Yeah. Oh, but I can't wait. I'm gonna definitely set aside some time for that because that is one of my favorite dishes here at the house.
Yeah. Sounds good. Yeah. I'm excited. I'm excited to try. I think it's gonna be great.
Also, I was gonna touch a little bit on maybe later on the Lord Valor thing. Me being a preacher, kind of knowing the Bible, and then
awesome.
There is a lot to that where I don't want to get too deep because I know how your channel works, but there's a lot to that caveat what she's doing and saying that's kind of biblical, and it even ties into Jesus himself, where the other side believes in
the casting.
Right. The other side believes in that is a normal thing to sacrifice people and to cleanse them of their sins and things of that nature.
But zombies?
But yeah, that's a bit much. Yeah, the zombie thing, kind of sort of in there when it comes to embalming and rising people from the dead.
That's
a little touchy,
though, right?
Right, that is a far fetch. If you read other books like the Apocrypha, it may kind of but not the word zombie. No, that I think that's kind of a man-made analogy on things. Yeah.
It's interesting. It seems. I mean, when you look at her behavior and what she's teaching, she's clearly, I think, using religion to accomplish her goal.
Right, like most cults do.
And she has to twist it. She's got to twist it to make it fit because it's the shoe doesn't fit very well, and that's why a lot of these people are like, yeah, it raised some alarm flags. I'm like, that's not what I'm familiar with, but yeah.
Right, but that's how they get people, though. You recruit people, you take something biblical or whatever spiritual book, and you can kind of twist it a little here and there to try to get people manipulated into it because, some things are not spelled out biblically, but people can kind of sway you in there by saying, well, this is what he meant when he said that, and that's kind of where, people say, how do you fall for something like that? How do people join cults and fall for things like that? Well, you can twist a lot of things that's been written that's incomplete, and then that's how you kind of get people. Yeah. Yeah, she's very adamant. She's very adamant in her. Yeah.
And she's aside from not making objections, which she should make, which number one, leading is the objection she should make after everything the state says. She's not doing terribly, but she's not accomplishing.
Surprisingly.
She's not bringing out the facts that would help her case. Instead, she's accomplishing the goal of trying to find out who wronged her and why.
Right. I was going to say, you hit it on the nose when you said she doesn't care. She knows she has life. This is more of a personal vendetta. I'm going to get my story out through these guys. I'm going to let them know how I feel. This might lead to a book she's going to write. And, you're really spot on when you come to, getting the bee's knees that's going on in court. So I think you really hit it on the nose.
It's a personal vendetta for sure. So
Right. This is personal. She gets her say, and she's gonna tell it. She doesn't care. I mean, I'm gonna look for the photo finish at the end when she does her closing, when she gets just railroaded by the judge and say, you have to be quiet. She's probably not gonna be quiet. She's gonna just say this big speech about how everybody's wrong and she's right, and kind of that kind of sort of thing at the end.
Okay, can I call it here? I think we're going to get a casting.
You're going on lunch break, right?
I am, but I think we're going to get a casting from her. She's going to full on declare everyone in court is dark, and
she's going to condemn the judge. She's going to condemn the jury. Yeah, she's going to condemn everybody. Maybe pay a bailiff to turn the lights down, dim the lights a little bit when she starts talking. It's going to be epic.
It's crazy.
She's going to go full out.
Yeah, but I don't think we're going to get. The evidence will not show that she's an innocent woman wrongfully convicted, wrongfully accused.
She's not a good murderer. I'll say that. She's not a pro. It's definitely going to come out easily.
And this is one of the few cases where we actually know the defendant is wearing a stun belt. She's got that shock system on her.
Right.
And let me just tell you, if something goes down in court, the cameraman will catch it. It's going to happen. And
it is.
And this might be the one. I'm just saying this might be the one where we see the what is it? The whale impersonation where you flop on the ground a little bit. It might happen. So somebody might have to push the button.
Yeah. Have we ever had a case like that where they had to push the button on your channel?
No, we haven't watched it. The closest we had was the Aaron Dean trial. In that trial, the judge in a previous trial had ordered a defendant to be shocked because he wouldn't answer the question.
Oh, they can do that if they don't answer the question. They hit the shock button?
No, they can't do that. They can't do that. But they did.
Is that on your channel?
No, I don't know if the video's out there. I think it's just a news story about it. But
I'll type it up. It's YouTube. I'll just say, man gets shot for not answering a question in court or something.
There it is. Master Ayden, it's always good to talk to you. Thank you, my friend.
Well, thank you for going on lunch break. We're going to have a verdict here soon because you went to lunch. So
yep,
this is always nice talking to you.
And we'll see you. Thank you, my friend. We'll see you. Bye.
All right, thank you.
I love it. Master Ayden's great. All right. The only way she's going to be shocked is if she is physically threatening someone, or that or she is a danger to the people around her. Okay, so she would have to be physically acting out in order for her to be shocked. That's the only case where rightfully she should be shocked. But if she gets really frustrated with how things are going, I'm worried for that.
Tanya. Call from.
Tanya, are you there?
Yes.
Oh, I pushed
Yes,
4
I
instead
am.
of 1, and I worried I had hung up on you. But welcome. How are you doing, Tanya?
Hi. I'm doing well. This is my YouTube is TK Sewing Machine and Repair, but my name is Tanya.
Right.
Yes.
Welcome.
Yes.
Good to put a name to your YouTube name.
Yeah. Well, it's a sewing machine repair bit, so I haven't even tried to change it. So yeah.
Before you talk, can I say something? Before I started doing YouTube, the last job offer I got was to do sewing machine repair.
Really? That's interesting. So my journey started because of the pandemic. And I lost my job, and I was also homeless. I was living with my son.
Oh, man.
And I started repairing sewing machines, vintage sewing machines. And in 6 months, I probably saved about $14,000 and put a down payment down on a house. I got a job, and that was, it was just kind of amazing.
You say vintage. Are you dealing with like baby locks and all the newer stuff? What is it, Hibernias, and are you talking more?
So I can clean and do general maintenance on a newer machine. Basically, if it has a circuit board in it, a computer board, I don't want to touch it.
Okay.
Those need to go to the Bernina baby lock dealerships and get them serviced.
Yeah.
But during the pandemic, you could not get a sewing machine brand new. The shelves were sold.
Same thing with
people were
telescopes. Weird. Everyone was staying at home and looking at the sky and sewing things.
So I would go and buy old machines, the old Singers made back in the 1920s, 1940s, and 50s. And I would oil them up, clean them, repair them, and resell them to people who were worried about, not having electricity because of the pandemic or whatever.
Oh, the preppers.
Everybody.
The preppers. You're going to have to sew your own clothes during the zombie apocalypse.
Yeah.
God,
I probably shipped 150 machines via FedEx all over the nation.
Wow.
It was crazy.
That's really cool.
It was crazy. Yeah. So but I had an idea about Lori Vallow.
Okay.
So stick with me on this one.
All right.
So what if you could get into the courtroom system for the lighting, and sound effects?
I like where this is going.
And
Go ahead.
And if you could just all of a sudden kind of dim the lights and put a spotlight on Lori Vallow and just say, I am Minorai, or whatever the name is.
This is your conscience. Yeah, no, that would be funny. Fully, just like it's bringing theater to the courtroom. I mean, the court is a theater, but bringing theater level effects to the courtroom.
I think it would freak her out.
Lori, you have not done as I instructed you. You must repent. Yes, you must repent.
We were never married.
Mrs. Chad. I mean, yeah. Oh man. Let me send an email to the judge. See what he'll let me get away with. I'm pretty sure none of that.
Okay, yeah.
None of that.
Yeah, well, I'm so glad that you're even entertaining the idea. I think that's amazing.
It's sad. I mean, this trial. I mean, for a lot of people, this is ripping old wounds open again, and I hate that part. I hate that part for the family and for someone who's lost somebody, just having to relive it and not just relive it, but face her as she, tries to drag them down every way that she can. This is a tough trial for the family for that reason. And Pro Se it just makes it that much worse because she gets to have her last little word and to get her word in edgewise and really, all the comments, any flaw that you have, she gets to drag out and present to the court, and the public. I don't like that part, but I do think that amidst all the heaviness and the seriousness of trial, we have to be able to laugh a little bit and have some fun, and I think that's appropriate. I think it's good.
Yeah, I agree. I believe this is her revenge against people that she thinks that, well, this is revenge against people who know her and what she said and did, whether they saw her and her brother kill Charles and or her children. So, when she's questioning the witnesses, it's so weird. The witnesses that she, that have a lot to say and have really damning things to say about her, no questions. Yeah. No question. But when she wants to just eat away at little different points, she'll, fight with a detective for 6 hours. It's really weird.
Yeah, and the hardest part is some of these witnesses, these people who've lived this, they've been instructed they cannot say anything about her being convicted for the deaths of her, for the murders of her children. And so they're having this conversation with the big elephant in the room that nobody can say, and they can't tell the jurors that they're dead, and that she's the reason why they're dead. And Lori even goes so far as to start talking about her children, how she's a mother, and I'm like, that is so wrong. And it's every part of me just wants to scream out, jurors, she killed him. It's like it was her. Not just Charles, but her kids.
Yeah. So. I have money that it's eventually going to come out, and it'll probably come out because Lori loses control.
And she's going to open the door. She's going to open the door.
Yeah.
It's going to come to the point where for her to get at somebody, she has to open the door. And I think she's going to do it because she doesn't, I don't think she cares about herself or about the outcome of the trial here. Either she doesn't care. She's like, whatever, I'm in jail for the rest of my life anyway. Or she is honestly delusional enough to think that spiritually God is going to step in and save her. And it doesn't matter, and she just needs to point out everyone else's flaws. It's one of those two, and I don't think it could be anything else. But she is acting like the outcome of this trial does not matter to her personally.
Yeah, I agree. I'm watching it because I'm in it for the entertainment value. And I know this sounds awful, but I just want to see her fail because she is so, I feel like she's just so evil and so self-absorbed into her, whatever it is that she's at.
Yeah. I'm sorry, I just chuckled because my wife just said, wait, you're saying pointing out everyone else's flaws is a problem? That feels pointed. Well, I'm glad we had this talk and learned about sewing machines. That's awesome.
Yeah. Well, thank you for talking with me today, Scott. I really, really enjoyed it. I enjoy your channel. I work from home, like a real job from home, and I watch all day.
Yeah, I don't
and
have
try
one of
to
those.
keep a happy I almost have as many computer screens as you do.
Oh.
I have my office set up like Tony Stark.
Yes.
And so I have 4 computer screens. I got a great big 70-inch TV on the wall, and I sit in an Iron Man chair.
That is really cool. Here's all we need to do now is get you live streaming your sewing machine repairs.
Yeah. I need better equipment. I just do it from my phone. But if you ever want to wander over to my channel, I got all kinds of videos demonstrating. Probably like 120 videos.
Can we do that together right now with you on the phone?
Oh, sure.
It's TK Sewing Machine Repair.
Yeah, TK Sewing Machine and Repair.
I'm going to bring everyone with us. Hang on.
Oh, this is fun.
Well, came right up top of the list. Let me bring us on. Let's see where we're at. Oh, man. Have to be on a different computer. Just one second.
Okay.
Turn the chat off so we can use this box really quickly. I don't have enough computer screens, believe it or not. Okay.
What you need are more buttons and more computer screens, Scott.
Did you hear that, Jen? Did you hear that? Tanya said it. Okay.
Clearly, we have proven it right now.
Okay. We're going to go to, we are on camera 5. 5 is where we're going. All right. Here's your channel. TK Sewing Machine and Repair videos, how to oil a vintage sewing machine. Can I play part of this and jump around in it?
Oh, yeah. Go for it.
Okay, here we go. We'll pause for a second. Let's look at this. Triflow clear synthetic grease.
And I put, I don't know.
Well, you've taken the whole thing apart. I was thinking you'd just have like a can of air duster and a Q-tip, but you're going and building the thing from scratch.
So
yeah,
the most
I take them apart. Everything that comes off with a screwdriver, I take it apart. I have a 4-gallon ultrasonic. I can almost fit a whole machine in there.
Yeah.
And I take them apart and rebuild them, replace parts that need to be fixed, and all that kind of stuff.
Okay.
Oh, thank you all for subscribing.
Let me put the link in here. If you can't find the link, it's right there in chat. So that's awesome. I love it. I love that you found something that you knew how to do and made it into a business that took you from in a tough spot financially to something where you're successful and loving it. That is really, really cool.
Yeah, it was So I'll say one more thing and then I'll let y'all go. But my son is a genius. He's really a genius, not just because I say so. He really is. And I was
not just mom
learning.
talking. Is that what you're saying?
Right. And I was trying to rewire sewing machines. So rewiring the motor, the pedal into a junction, so it goes into the machine and it runs. Mm-hmm. And my son, I was like, I just can't figure it out. I can't do it. And my son was like, Mom, he goes, I don't know how you didn't burn my house down. He goes, but you've done it all wrong. So he had to teach me, just the concept of how electricity works.
If he's available, I still have to wire my bathroom, and I'm super nervous, especially after we watched this trial with Linda Stermer, that if I wire it wrong, the whole house could burn down.
Oh my gosh. That trial, let me tell you, oh my goodness, that one is just, those 3 boys up on the stand.
Oh yeah.
It was just heartbreaking. It's heartbreaking.
Yeah. It's been tough.
Yeah, and tough. Really, really tough. Well, Scott, I got to get back to work, but thank you.
Tony, it's good talking to you.
taking the time to talk to me today. I really enjoyed it.
Yeah, thank you. We'll see you.
Okay,
right,
thank you.
bye.
Bye.
Love it, love it. Okay, so here we are. We're at lunch. This is what I'm going to do. We're going to portal over. I have to close out because we're over 5 hours right now. I have to close out this live stream. I'm going to open the next one, but I'm going to have it open just like this. So it won't be waiting for me to start. I'll be live, but I'll be in another room eating, I don't know, thinking about eating enchiladas. And we're going to come back this afternoon and continue verdict watch. Maybe watch a little bit more of the Lori Vallow hearing because they're at lunch right now, I think. Pretty sure. Where's that remote? That's this one. Okay, yeah. So we'll come back and portal over. So give me a minute to build the portal. We will come back for verdict watch part 2. Man. All right. And we're going to come right back with that. So we'll be live, and I'm just going to perhaps get a verdict after lunch. Possible. Building the link, opening the portal, charging the portal, checking the seat belts. Okay, now we're set up. All right. Here's what we're going to do. I'm going to go to lunch. When we come back, we're going to continue with our verdict watch. We've passed 4 hours and 20 minutes of deliberation. I know that's an important number for some of you. So 420 is gone, come and gone. Jury continued to deliberate in the case of Michigan versus Linda Stermer. Did she, in fact, commit murder by lighting her house on fire and then running over her husband with the van? So we'll see. When we come back, we're also going to be watching some of the highlights from yesterday's Lori Vallow trial and maybe a couple other courts if something else pops up. So we'll be jumping around. It is Friday. The weekend is nearly upon us. I'm going to try to talk Mrs. O'Reilly making another trip back to the store because she's already done all the shopping. And she didn't get the enchilada stuff. At least not the right stuff yet. So we'll see. Tonight, when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again in minutes, but it will be in lunch. It's going to look like this, but without the music. It'll be like that. That's what we're going to come back to. And so hang on, we'll see. Will someone sell me a cheap serger? Quick. Go to the murder Walmart. They have everything. All right, we'll see you guys. Be good. We'll see you in just a little bit. Bye-bye.
I don't like podiums, Your Honor.